confirm colleagues who are here. Honorable Weber.
Morning.
Yes, good morning to you. Honorable Bryant.
I'm here, Chairperson.
Honorable Mutisa.
I'm here, Chair. Good morning.
Okay, good morning to you too. Trying to check other members. That's fine. Honorable Phillips. Good morning.
Morning, ma'am. How are you today?
It's good. I'm good, and you?
I'm great.
Those are the members. Deputy Minister, good morning. Deputy Minister.
Good morning, my chair. How are you, Chairperson?
I'm good, thanks. And you? I thought you were also playing golf.
No. I'm in Bloemfontein. I wasn't in Cape Town yesterday.
Oh, I see. Okay. Then we need to then start. I think I've got the following apologies. Honorable Gancho will join the meeting a bit later. Then also the apology from the minister. And then NTUC, the deputy minister is the leader of the delegation. So the minister is apologized. Then, yeah, those are the apologies that I'm having at my disposal. We have a very long agenda today. Chileka, if you can show it in the screen so that the colleagues can see it. Not the legal opinion. The agenda. So we are going to first get a briefing by the Parliamentary Legal Services on the National Environment Management Laws Amendment Bill. Then the Department of Environmental Affairs, Forestry, Fisheries, they will also then do the same brief. Then we'll have to decide on the way forward. And then we're going to then have a briefing on the National Forest Amendment Bill. Then we'll get the briefing from the various stakeholders. That's your National Disaster Management Center, SALGA, Department of Agriculture, Land and Rural Development, Department of Public Works. They are saying no comment. We got a letter from the minister. They are happy with the bill. Then we'll have the South African Weather Services, and then the National House of Traditional Leadership. Then that's how the agenda is. Having said that, I can see we have got a lot of colleagues who are in the meeting. I think for the sake of time, safe to say, I need to welcome you, Minister, and the entire management team from the department. Also to welcome the colleagues from the Parliamentary Legal Services and the colleagues from the National Disaster Management Center, colleagues from SALGA, colleagues from Agriculture, Land and Rural Development, including the colleagues from the National House of Traditional Leaders. As and when we deal with the presentation, I think the presenters will have to introduce themselves. But for now, I should think then I need to hand over to the parliamentary. Before that, colleagues, can we then adopt the agenda? This is as what we have agreed on in our program. Can I get a mover? And the
Chair, I propose that we adopt the agenda and try our best to stick to the time frames. Thank you.
Thank you,
Chair.
so much.
I'll second my colleague.
Moved by Honorable Bryant, seconded by Honorable Phillips. There we go. Then can I therefore hand over to the Parliamentary Legal Services team? There are two colleagues. There's Mr. Siviwe Njikela and Mr. N. Mjekane. One of the two will definitely lead us on this. Over to you.
Sorry, Chair, before that, there's an apology from Honorable Singh. He's traveling, therefore he will join the meeting in the afternoon.
Okay.
Yeah.
It's fine. Honorable Mdise's hand is up.
Chair, I thought I must just register my apology. I have a flight in the afternoon at 5:30. But for the better part of the meeting, I am present.
Up to 3:30 or 4.
Yeah, well, I'll still be connected at the airport, so up until 5:30 exactly.
Okay, then we should be done by then. I hope we'll be done by then.
Knowing this portfolio committee, we might finish at 10, but I'm just putting it out there, Chair.
It's a Friday today, Honorable Member. Please. Then let's proceed over to the Parliamentary Legal Services team.
Good morning, Honorable Chair and Honorable Members. I am Siviwe Njikela. I'm standing in for Mr. Mjengana to present the legal opinion that was circulated to the committee. It is not always the right way to start with a disclaimer, Chairperson, but I think I should.
Why?
As you will know, Mr. Mjengana is the legal advisor assigned to the committee to deal with this bill. But unfortunately, because of other commitments, he's not able to do the presentation, so I had to step in. So if I do...
The law is the same. Proceed.
If I do seem hesitant at times, please do understand. But I will do my best to present the legal opinion. Chairperson, I'm moving from a position or from an assumption that the legal opinion has already been circulated.
Yes, it has been circulated, and the members, have read it. Yes, proceed.
I will try, Chair, not to bore you by reading directly from the legal opinion, but to just highlight what the key features of this legal opinion are. But if there is anything that the committee feels that it was not covered in my summary, I think that can be extracted from me through questions at a later stage. So that's the approach I intend to take. Chairperson, as we understand it, we were requested to give advice to the committee on possible courses of action if the committee at all feels that the current amendment bill no longer serves the issues for which it was originally introduced. And that is the question that we try to answer in the legal opinion and provide various possibilities in terms of the Constitution and the rules of the National Assembly. Chairperson, the committee will recall that the joint taking mechanism classified the bill as a 76. In other words, a bill that affects, an ordinary bill that affects the province. And for that reason, and I think that's why we are dealing now with the amendments that are proposed by the NCOP, because of the kind of classification that was given to it. And I'm saying this not to suggest that there was anything wrong with that. In fact, we believe it was a correct classification. But I just thought for the record, it should be repeated here, that that was the tagging that was given to the bill. Hence the extensive process and amendments that are now being proposed to the NA by the Select Committee. I then proceed, Chair, to just briefly look at some of the provisions of the Constitution that are relevant for the kind of consideration we have to do. And I will go back again to the issue of tagging just to close it out. Chairperson, you will remember the criteria for the classification of bills either as 74, 75, 76, 77 is based more especially on 76. The Constitution says any matter that is listed in Schedule 4 of the Constitution is a matter of concurrent competency between the provincial and the national sphere of government. Now, it is common cause that environment is listed in Schedule 4. That is exactly the reason why I was saying the tagging was correct in as far as environment is listed as one of the issues listed in Schedule 4 of the Constitution. But then, Chair, we proceed to Section 76 as to what it says to us in terms of how between the NA and the NCOP we should be dealing with the bill. And we start with Section 76(1) of the Constitution, which provides that when the National Assembly passes a bill, referred to in subsections 3, 4, and 5, the bill must be referred to the National Council of Provinces and dealt with in accordance with the following procedure. In other words, it prescribes the procedure that the NCOP must follow in dealing with that bill. Now, Chairperson, it is common cause that the bill had already been considered by the NA, passed by the NA, and referred to the Council. And these are the relevant considerations. Section 76(1) tells us that the Council must either pass the bill or pass an amended bill or reject the bill completely. Now, we know that the Council has chosen subparagraph 2, which is to pass the bill with amendments. If the Council passes the bill without amendment, the bill must be submitted to the President for assent. Now, again, we know that did not happen because the Council has proposed amendments. This is what subparagraph C tells us. If the Council passes an amended bill, the amended bill must be referred to the Assembly. And if the Assembly passes the amended bill, it must be submitted to the President for assent. And I think this is the space, Chairperson, where we are in now. It has been amended by the NCOP. It has now been referred to the NA. And the NA has referred it back to this committee for consideration of those amendments. In terms of the foregoing, the NCOP passed the bill with amendments in terms of 76 sub 1, which is what I've already stated. The bill has been referred to the NA, as I've already stated again. In terms of 76(1)(c), the Assembly has an option to pass the amended bill and submit it to the President. Now, this is where, Chairperson, the consideration of this committee is required, whether it accepts the amendments and pass the bill as it is, or if it does not agree, it may refer it to the mediation committee. And then I will proceed, Chairperson, to speak about the provisions that relate to an instance where the committee does not pass the bill as it is, as amended by the NCOP. And the relevant provision, again, we cited there, it's Section 76(1)(d) of the Constitution, and it provides that if the Assembly refuses to pass an amended bill referred to it in terms of paragraph C, the amended bill must be referred to the mediation committee, which is the summary that I've just given. The mediation committee may agree on the amended bill as passed by the Assembly, alternatively as passed by the Council, or it may effect its own amendments and produce a different version. if the bill will lapse if the mediation committee is not able to agree within 30 days of the bill's referral. Now, maybe I should remind the committee that upon referral by the National Assembly to the mediation committee, the mediation committee only has a 30-day period within which to finalize the matter, hence the reference to 30 days. Paragraphs F and G of subsection 76(1) of the Constitution provide that if the mediation committee agrees on the amended bill as passed by the Assembly or the Council respectively, the bill must be referred to the other House. If the bill is passed by either the Council or the Assembly, it must be submitted to the President, which is the normal process for Assembly. On the other hand, if the mediation committee agrees on another version of the bill, in other words, a new version, that version of the bill must be referred to both the Assembly and the Council. And if it is passed by the Assembly and the Council, it must be referred to the President for assent. Now, in terms of Section 76 of the Constitution, the Assembly has two key options as of now. The first option, Chairperson, is for this committee or the National Assembly to pass the amended bill, in which case the bill will be referred directly to the President for assent. The second option, I'm just summarizing what I've said above. The second option will be for the Assembly to reject the amended bill, in which case it goes to the mediation committee to take a decision within the 30-day period I've referred to. As already stated again, the mediation committee may agree to pass the amended bill. The bill as passed by the Assembly then goes forward, or pass another version, which then that version must go both to the houses. If the committee fails, that is the mediation committee fails to agree on the way forward within 30 days, the bill will lapse. In respect of the latter, it may not necessarily be the end of the day, because it is only the Assembly that may save the situation by passing the bill, again with a 2/3 majority. But you will see now that the bar is being moved a little bit higher, because you can only revive it by 2/3 majority of its members. Chairperson, I will now briefly speak to the rules of the National Assembly. And the rules of the National Assembly simply reinforces what the Constitution already states. So I'm not going to say much, and then I will proceed to what is the conclusion of the opinion. We repeat, Chairperson, that if a bill has been sent back, the Speaker must submit the amended bill to the Portfolio Committee, which is exactly what has happened now. That's why it is before. And the committee is supposed to deliberate and prepare a report with recommendations on the Council's amendments. That's why your two options are to either accept those amendments or to reject them, and then the National Assembly must make a decision. Chairperson, again, Rule 3112 repeats what I've already said, that the committee to which the Council amended is referred may consult. So in other words, may consult the appropriate Council committee or the chairperson of that committee. So as you consider the bill, if you deem it necessary at any point of your consideration, you are free in terms of Rule 311 to consult with either the full committee or the chairperson of that committee in as far as those amendments are concerned. But the committee may not propose any further amendments to the bill and may consult with the JTM on whether any of the Council's amendments changes the JTM classification or renders the bill constitutionally or procedurally out of order within the meaning of Joint Rule 161. Now, Chairperson, maybe I need to explain a little bit here. It is possible that in a consideration of a bill by the NCOP, that the extent of the amendments in that bill, it goes as far as to affect the classification that has been given to a bill, either a 76 or 75. In some instances, a 76 bill, by virtue of the amendments made, may change to a 75, or a 75, because of the amendments effected, may end up being a 76, depending on what each house has done to that bill. In that case, this provision simply says you must then consult the joint tagging mechanism for the review of that classification. I'm not sure if that is the case here. In NA Rule 312 provides as follows, Chair. The committee to which the Council's amended bill is referred must table in the Assembly its report and recommendations. I've already spoken to this, Chair. The Council's amendment, when the report is tabled, the Speaker must place the report and the Council's amended bill on the order paper, which is the normal process of Parliament. But I think what is significant is, again, the emphasis that the committee, in terms of Rule 313, may not effect any further amendments on that. If it refuses to pass it, it goes to the mediation committee, and the solution lies with the mediation committee. Chairperson, I will move to the conclusions, which again is a summary of what we have already alluded to in the body of the discussion. We now know the NCOP passed the bill with amendments in terms of Section 76. The Assembly has two options, which is what is before this committee, is to pass the amended bill or to reject it, in which case it must be referred to the mediation committee. And the mediation committee has 30 days from day of referral to resolve that issue. If it is not able to do that, the bill will lapse. But Rule 311, as we just indicated, gives this committee an option, if it deems it necessary, to consult with its counterpart in the NCOP or with the chairperson of the select committee that resulted in the amendment. Now, what is an expectation from this committee, legally speaking? It is expected for the committee to consider the bill, prepare a report with recommendations, and table it before the Assembly. The recommendation, as we already indicated, Chair, may include a rejection. On the tabling, the Speaker must place it in order paper for debate. Were you saying something, Chair?
No. Let me check who the culprit is. I'll let you know. You can proceed. I think it's somebody, that person at hindsight, or is already muted his or her microphone. I'm sorry about that.
All right, Chairperson, thank you. So, Chairperson, it comes back to the options which we have already alluded to above. That you have an option to consider the bill as amended, consult with your counterpart committee in the NCOP, make a decision whether you want to pass it as it is, or you want to reject it, in which case it goes to the mediation committee. And Chair, I think that briefly are the options or courses of action that are available to the committee, in line with what has happened since the bill went to the NCOP. I don't know, Chair, if there is anything else that I may have to cover. I've tried to summarize the opinion without really reading throughout all the relevant paragraphs. Chair, I thank you.
And I wonder where lies the disclaimer, because you've eloquently explained the legal opinion. Thank you so much.
Thank you very much.
Okay, colleagues, here is the advice from the Parliamentary Legal Services. Can I get a proposal from the colleagues, or are there questions for clarity before we take a decision?
Chairperson, sorry, I'll raise my hand.
Sure. I'm trying to check. Yes, there are 3 hands thus far. It would be Honorable Bryant, Honorable Paulson, and Honorable Phillips in that order. Over to you, colleague.
Thank you,
Honorable
Chairperson.
Bryant.
Thanks, Chairperson. I just want to find out, after the legal presentation that we've just had now, should we be looking at the proposed amendments first? I mean, we have been sent them as the committee and taking that presentation before we make the decision, or is he suggesting that we make the decision now in anticipation of that?
Okay. Less than. I hear what you're trying to say. Honorable person, is it the same thing or is something different?
No, it's actually the same. Chairperson, I also think that maybe we need to, after having considered those amendments, consult with our counterparts in the NCOP as well, Chairperson.
Okay. Then consulting, but we have got the power to take the decision as per the legal opinion, unless if the clarity is seeking question. But the difficulty with us isn't that it was passed in the previous parliament. The department is going to take us through to say this is where the bill was, and these are the amendments that our counterparts has effected in the NCOP. Honorable Phillips.
Thank you, Chair. I've got some reservations. I would also like to know what the debate was and what the opinion was of the NCOP. The legal opinion was very much based on the procedure that the bill is going to follow and not so much on the constitutionality of the bill. I would have liked to have seen some input on them on the constitutionality of the bill. And then, I also would like us to look at the amendments jointly very carefully. Thank you very much.
Mr. Njikela, before you come in, once the bill on the constitutionality of the bill, I think the president will have to deal with that once it's submitted for him for ascension. But definitely when it was initially passed, the colleagues who were there before us should have considered that with the help of the legal services. Then the other issue, I should think we need to go the route that Honorable Bryant has proposed to say, let's then hear what are the issues, what is it that the NCOP has amended. But before I allow the team to take us through that, let me ask Mr. Njikela to respond to some of the concerns as raised by the colleagues.
Person, may I perhaps start with the last point you made, and then go up to the first question. Chairperson, the normal procedure is that when a bill is introduced, it has already been certified by the Office of the State Law Advisor as being constitutional. But before it goes to the joint taking mechanism, again, the Parliamentary Legal Services provides an advisory to the JTM in terms of constitutionality and whether the bill is in order in terms of the rules. So that would have happened at the time that it was introduced in Parliament and when it went to the joint taking mechanism. But of course, Chairperson, it's possible that in the course of being considerations, there may have been changes to the bill, which may raise the issue of constitutionality. And this is where I will plead that, because I haven't had the opportunity to consider that. As I said, I'm standing in for somebody. But from my discussion with Mr. Mjengane in preparation of this for this meeting, I didn't get a sense that there were concerns about its constitutionality. Having said that, Chairperson, I want to go back to the first question then. Chairperson, I suspect if it is before you again after the NCOP, you can only make that decision after having considered what the NCOP is proposing. So you can't make that decision without having considered content of what is being proposed. And I think that's where the question of rationality comes in. You can't make a decision about something you haven't even seen or considered. So there must be a consideration, and based on that consideration, there must be a decision about what the committee will do. And of course, the point that was made about consultation, that consultation which is provided for in the NA Rule 311 will then have to happen in the course of that consideration if the committee feels that there is such a need or there are clarification that it seeks from the NCOP. And I think, Chair, that those are the issues, 3 issues that were raised. Thank you very much.
Thank you for that much needed clarity. I should think then there's no confusion. We need then to put the matters for considerations, and as and when we progress, then we are going to, if there's a need for us to further consult with those that have put all these new things in the bill, we'll have to then arrange a meeting with the counterparts in the NCOP. Can we then get into the details? I should think the DFFE will be able to tell us to say at the time of the adoption by the NA, these were the issues, and now these are the new things that the NCOP has put in. Who's dealing with that from the DFFE side?
Chairperson?
Yes.
Deputy Minister
Yes,
here.
Deputy Minister must introduce the bill.
No, thank you very much, Chairperson, and good morning to all the participants in this meeting and members of Parliament. Chairperson, our DG, Ms. Chabalala, is here with the team from DFFE. She will then take us through the issues that members wanted clarity on, especially on the issues of the amendment. What is it that has been amended, and what is it that then the NCOP amended and then sent it back to the NA? So Ms. Chabalala is accompanied by our legal team. I think, Ms. Chabalala, you can just take us through, introduce your team to the chair and the committee, and then you can quickly then take us through this. Ms. Chabalala is going to be with us until lunchtime. I will be in until the end of the meeting. She's got another meeting that I was supposed to attend. I requested her to stand in for me. Thank you very much, Chairperson. Ms. Chabalala?
Thank you very much, DM. Thank you, Chairperson. Good morning, and good morning to the honourable members. With me, I have various DDGs from the department, and as and when they speak, they are then going to introduce themselves. But the key branch that is going to be taking the committee through this bill and the amendments is mainly the branch of regulatory compliance. And I have 2 colleagues, Ms. Linda Gallup, who is from the branch, and also Ms. Francis Craig, who is acting for today, given that the DDG also had an emergency to deal with. There's also Dr. D. Fisher, who's also from the branch. Chairperson, I'm requesting that we take the committee through the amendments, and we then can be in a position to highlight what the amendments entail and what would have emanated from the NCOP as part of the bill being processed by the NCOP. So I'm requesting that I hand over to the team to take the committee through the presentation, Chair.
Okay, who's doing that?
Thank you. Good morning, Honourable Chair. This is Frances Craigie here. I'm going to take you through the presentation.
You've become a regular. You've
Chair,
become a regular in this committee.
I think so, Chair. Yes, I enjoy this committee. Thank you very much, Honourable Chair and Honourable Members. I'm going to take you through, it's quite a lengthy presentation, but we felt that it was quite important to do so, obviously, given the legal implications that you heard about this morning. So this presentation is with the members of the committee, and then in addition to the presentation, we also have provided you with a very comprehensive table. I think it's over 100 pages, which really then shows you the different amendments and the different bills and the changes that were made as they moved through that process. So let me just put this on slideshow and just confirm that you are able to see it.
Yes, we are able to see it.
Wonderful. Thank you. So what I'm going to do to start off with is I'm going to just take you obviously through the purpose. And the purpose is to provide the Portfolio Committee with an overview of what happened with this particular bill. There's background. I'll touch on the consultation that happened before the bill was even introduced to Parliament. I'll then move on to the way in which it was introduced, which was back in May of 2017, the purpose of the bill, the process as it was consulted in 2017, how it was then amended, the referral to the NCOP, and again, importantly there, how it was amended at that point, and then just a summary before we then obviously go to the questions. So this slide, as you know, we enjoy quite a lot of acronyms within the environmental sector, and so we just put this slide in just to ensure that we are all familiar with the acronyms, particularly around the different pieces of legislation. So when it comes to the background for this particular bill, the National Environmental Management Act, as the committee would know, is our overarching umbrella legislation for the environment in the country. And it is an overarching act, but there are a number of specific environmental management acts that fall under this. And they're acts that deal specifically with air, biodiversity, coasts, protected areas, and waste in more detail. And the amendment bill that I'm going to talk to also looked at amending some of these other specific environmental management acts. And then importantly, as the law advisors were talking about this morning, NEMA is not only implemented by our department at a national level, but also by 11 competent authorities, so all the 9 provinces, as well as the Department of Minerals and Energy. So if we go into the purpose of this National Environmental Laws Amendment Bill, the main purpose was to amend the following acts, and I've spoken about some of those already: Protected Areas Act, Biodiversity Act, Air Quality Act, Integrated Coastal Management Act, the Waste Act, and then also one of our previous amendment acts of 2008. And so the main purpose of the bill is to provide clarity on certain issues, to address competencies and powers of various competent authorities and licensing authorities, to address operational and implementation challenges, to also make textual and consequential amendments, and to provide for matters that had not been previously catered for in the legislation. So, for example, looking at the definition of well-being of animals. So consultation prior to the bill, and it's important just to know that this bill goes back a number of years. So you can see there in terms of the NEMLA bill and the way in which we consulted it, it was approved by Cabinet back in 16th of September 2015. So we're talking almost 7 years ago. And it was published for comment in October of that year. The closing date for the public comments was the end of November 2015. And in response and with the comments coming through, we received a total of 29 sets of public comments from various stakeholders, including the business sector, non-governmental organizations, as well as the different spheres of government. And the comments that were received were on matters such as integrated environmental management, clarity around the implementation of the One Environmental System, which is the system between environment and mineral resources, the support for strengthening of compliance monitoring and enforcement mechanisms. Clarity was sought on proposed amendments to the definition of waste, residue deposits and stockpile management, and then also on certain transitional arrangements. The comments were then considered and consulted in detail during the course of 2016, and most comments received were addressed. And then a revised bill was provided at the end of 2016 with a classification of certification of the bill by the Chief State Law Advisor in November of 2016. So following that, it was then introduced to Parliament in May of 2017. And now I'm going to take you through the content of that bill that was introduced into Parliament at that time. So it was aimed at correcting and clarifying the meanings of certain terms and definitions, such as constitution, such as the Environmental Mineral Resource Inspector, also clarifying issues around financial provision for the rehabilitation of environmental damage caused by mining and related activities. It looked at adding a new environmental management principle promoting transformation and diversity in the sector, namely the full participation of Black professionals in the environmental management sector to be recognized and their participation in the sector promoted. Looked at refining empowering provisions in respect of regulations for environmental management instruments and to remove the list of these instruments from the text. Require that the minister to keep a register of all environmental management instruments adopted in terms of the Act. It also went further to strengthen the integrated environmental management system and clarify sections dealing with applications for environmental authorization and the roles of different authorities in this process, and to provide for integrated decision-making where possible. It would provide clarity on Section 24G applications. These are the ones where listed activities begin without an environmental authorization and are therefore illegal. And Section 24G was then opened up to allow a successor in title or a person in control of the land to also apply in terms of Section 24G to rectify that unlawful activity. Provide the minister with the power to set minimum information requirements for environmental management programs, to allow environmental assessment practitioners to consult with organs of state in course of applications for environmental authorization, and then also to amend Section 24P, which deals with the financial provisions for the rehabilitation of damage caused by mining. It then also empowered the Director General of the department responsible for mineral resources and the municipal manager to issue Section 28(4) directives. Previously, only the DG of our department and the HODs of the provincial department could issue these directives. So it empowered them to do so in the event of serious harm to the environment. Provided clarity that Section 28 is applicable to anticipatory costs as well as remedial measures. And then at that stage, it provided for joint and several liability in respect of the responsible persons listed under that duty of care in Section 28. It went on to empower the minister responsible for mineral resources to designate environmental, mineral, and petroleum inspectors from their staff within that department or from an organ of state that falls under DMRE. It empowered the member of the Executive Council to designate environmental management inspectors to undertake compliance and enforcement, specifically in relation to their provincial environmental legislation. It empowered the minister to prescribe a code of conduct for environmental management inspectors and environmental mineral and petroleum inspectors, and then provided clarity that an environmental mineral and petroleum inspector must also undergo approved training before they're designated as those officials. It provided clarity on functions and general powers of EMIs when conducting investigations, and it also then provided clarity that the conducting of a search, which is really a function associated with a criminal investigation, is not the primary purpose of an EMI when they undertake a routine inspection. So it just provided that clarity within that legislation. It also then provided clarity that an EMI may detain an item for further analysis or for verification purposes of determining compliance and not within that applicable legal requirements. So they could detain it in order to determine that compliance. It provided clarity that the minister's power to develop regulations on admission of guilt fines contextualizes the related provisions within the Criminal Procedure Act. So just to ensure alignment between those two pieces of legislation. And then empowered the minister responsible for mineral resources, minister responsible for water affairs, and a municipal manager to delegate functions and duties in terms of this act, as those delegation powers hadn't been provided for previously. It provided clarity that a person may appeal a Section 28(4) directive issued by a person acting on a delegated authority, but that an appeal against a directive does not automatically suspend it, because we know that those directives are normally issued in urgent circumstances. Provided clarity that an appeal against a directive must be lodged at the appropriate appeal authority, and then it also made sure that there were correct references and cross-references to offences and penalties to update the list of offences. It then further, those were all the amendments that it made to NEMA, and then it further made amendments to some of our specific environmental legislation. So in terms of the Protected Areas Act, it clarified that the Chief Financial Officer of Sandparks is part of the Sandparks Board. It also introduced a new offence for non-compliance with Section 48A, which prohibits certain activities within a marine protected area. It then made amendments to the Biodiversity Act, again specifying that the Chief Financial Officer of SANBI is part of the SANBI Board. In terms of NEMLA as well, the Biodiversity Act, some of the definitions and provisions relating to alien and invasive species were amended, specifically those terms around control and eradicate. One of the objectives for the Biodiversity Act has also been amended to provide for the use of indigenous biological resources in a manner that is ecologically sustainable, including taking into account the well-being of any faunal biological resource involved. It allowed the minister and ensured that she could authorize specific circumstances under which landowners must then report the presence of invasive species on their land and take steps to control or eradicate those species. And the bill clarified that the MECs must also follow consultation and public participation processes when taking decisions in terms of the Biodiversity Act. Then when it came to the provisions that it looked at in terms of the Air Quality Act, it changed the current mandatory requirement that the minister must establish the National Air Quality Advisory Committee to a discretionary power that may be exercised. It provided clarity on Section 22A of the Air Quality Act regarding the consequences of the unlawful conducting of listed activities by inserting a provision that authorizes a person who has commenced illegally with that activity without the atmospheric emission license to apply for an authorization to continue the activity, subject obviously to the payment of an administrative fine. It also provided for two scenarios, namely for those activities that were operated without a registration certificate under the old Atmospheric Pollution Prevention Act, and those activities that have an environmental authorization but no license under the Air Quality Act. Provided clarity that a provincial department responsible for environmental affairs is the licensing authority, where listed activity falls within the boundaries of more than one municipality or more than one district municipality. Then in terms of the Integrated Coastal Management Act, the amendment bill clarified the retrospective effect of Section 60 of the Act, which allows for the issuing of notices for the removal of illegal structures built in the coastal zone before the coming into effect of that Act. So currently, the retrospectivity is implied, but it's not clear, and therefore that clarity was inserted through this bill. It corrected the current situation where the minister is the appeal authority for certain decisions taken by an MEC, and the MEC is the appeal authority for decisions taken by the municipality. The repeal of the provisions will have the effect that appeals will be dealt with now under Section 43 of NEMA. The Waste Act, it looked at all the definitions from Schedule 3 were removed to Schedule 1. So Schedule 3 was also replaced. It provided for a textual amendment at that stage to the definitions of residue stockpiles, residue deposits, and then waste. It excluded the residue stockpiles and residue deposits from the provisions of the Act, which meant that the residue stockpiles and residue deposits would be dealt with in terms of NEMA. Continuing with the Waste Act, it clarified that the minister responsible for mineral resources is also responsible for the regulation of waste management activities insofar as they are conducted as part of mining operations, which obviously brought that in line with the One Environmental System. Provision has been made in this bill for the constitution of a board for the Waste Management Bureau with its explicit powers and functions. It amended the provisions to ensure that a site assessment report and a remediation plan regarding contaminated land are submitted together to the minister for approval. It clarified that no exemption from the requirement to obtain a waste management license may be issued, and it enabled the payment of processing fees when the applications are made for variation of waste management licenses. And then it also sought to update certain offences and penalty provisions. Then lastly, it also looked at providing certain clarity around the National Environmental Management Amendment Act, which had come in 2008. And so it is still relevant as it contains the transitional provisions relating to the switch to the One Environmental System in December of 2014. So there are still some matters that required clarity, namely to specify when the requirements of NEMA and when the requirements of the MPRDA are regarded as having been fulfilled insofar as they relate to activities that were commenced before or after December 2014. So this amendment bill sought to really clarify that position. It also clarified that appeals that were lodged against decisions taken before December 2014 in respect of environmental aspects in terms of the MPRDA must be finalized in terms of the MPRDA and not in terms of NEMA. And it also provided for transitional provisions in respect of residue deposits and residue stockpiles and the continued operation of the Waste Management Bureau before it can be properly set up in terms of the proposed provisions. So that's the long story about what it was that this NEMLA bill was aimed at doing. And as I said, it was introduced into the National Assembly. At that time, that is the latter part of 2017, the department then briefed the then Portfolio Committee on the content and the intended purpose of the bill. The Portfolio Committee considered the bill between mid-2017 to mid-2018 and invited comments on the bill. There were public hearings that were held, many comments and representations were made as part of that process, and a range of stakeholders, including industry, business, and non-governmental organizations, participated in that process. The Portfolio Committee then considered all of the inputs made and prepared a B version of the bill, containing the following main amendments to the original tabled bill. So they added the definition for audit to mean a review of the scientific and engineering acceptability of the measures and the adequacy of related costs associated with undertaking progressive rehabilitation, decommissioning, closure and post-closure activities for listed and specified activities, including the pumping and treatment of extraneous and polluted water where relevant. They added a definition for the word black in respect of the newly added NEMA principle. They added a definition of environmental management instrument. Additional changes were also made at that stage to the financial provision requirements, for example, through the addition of and changes to relevant definitions and the expansion of the financial provisions section of the bill, also leading to specific provisions for financial provision for mining in the bill. They amended Section 24G provisions to make certain requirements compulsory when applying for an environmental authorization or waste management license in order to rectify legalized activities that commenced illegally, and they specifically added public participation requirements to the 24G provision. And they also then increased the administrative fine that is linked to Section 24G from an amount of a maximum of 5 million to a maximum of 10 million rand. They also then changed the term environmental mineral resource inspector to environmental mineral and petroleum inspector throughout the bill. They made additions to certain powers of these inspectors, and consequential amendments to the enforcement provisions were then required. And they added consequential amendments to Section 42B regarding delegation powers and to Sections 49A and 49B regarding offences and penalties. Then in terms of the amendments to the Protected Areas Act, they amended Section 48, which relates to the prohibition of prospecting and mining in protected environments unless a permission is applied for, and the criteria under which such permission may be, and the application may be then be rejected or the permission may be issued. So in the past, the prohibition was outright, but now there is a permission that can be required around this issue. In terms of the Integrated Coastal Management Act, they repealed the whole of Chapter 9 as it duplicated appeal provisions already catered for in NEMA. In relation to the Biodiversity Act, they included a definition for well-being and empowered the minister to prohibit activities that may negatively impact on the well-being of a faunal biological resource. They added a provision that the minister must provide education and awareness to local communities affected by listed invasive species, and also added regulation-making powers in respect of the well-being of animals. In relation to the Air Quality Act, amendments similar to that of NEMA Section 24G were added to Section 22A of the Air Quality Act, which obviously deals with the consequences of illegal and unlawful conduct, and they enabled the revocation and suspension of an atmospheric emission license in certain circumstances. In regard to the Waste Act, they inserted a definition for general waste, and Schedule 3 of the Act was repealed. The schedule set out the different categories of waste. However, it is regarded as being largely unnecessary. Some of the consequential amendments were made due to the repeal then of that section. And then in relation to the Amendment Act of 2008, there was a consolidation and improvement of various transitional provisions, which are similar in content. So those were the amendments that were then made to the bill by the Portfolio Committee back then. And then basically on the 8th of November of 2018, the Portfolio Committee considered and adopted the National Environmental Management Laws Amendment Bill with these amendments, and that bill then became the D Bill. So the main changes contained in the D Bill are more specific provisions and changes were incorporated, as I said, in terms of 24G of NEMA. Section 31D4 had been amended to enable the minister, after consultation with the Minister of Mineral and Petroleum Resources, if it is necessary to address significant harm to the environment, to be able to direct an EMI to provide support to the enforcement officials within mineral resources. Inclusion of a section into NEMA to enable appeals to a municipal council on decisions taken by an atmospheric or the licensing authority, basically, in terms of the atmospheric emission. NEMPA, which is the Protected Areas Act, changes to Section 48 provisions relating to mining in protected environments. In terms of the Air Quality Act, changes to revocation and suspension provisions of Section 47A, and then amending the long title of the bill to reflect all preceding amendments that had been made. So that D Bill then went across to the NCOP. They passed it and referred it to the National Council of Provinces to deal with it in terms of Section 76 of the Constitution. However, at that time, there were various delays. And so the NCOP did not deal with that bill as contemplated by Section 676, basically because of the expiry of the fifth administration term at that particular time. So it was only then in October of 2019 that the NCOP, on advice from the Parliamentary legal advisors, decided to revive certain bills which had not been finalized when the term of the fifth administration ended. And so this included this NEMLA bill. The timing of consideration by the NCOP unfortunately also coincided with the COVID-19 pandemic and the national lockdowns, but the NCOP, through the Select Committee, did engage on the bill. A number of public hearings took place within provinces, numerous virtual engagements. Select Committee also engaged with the National Department on many occasions and carefully considered all the content and inputs that were received from the different provincial legislatures. The process was halted during 2021 as a result of the announcement of municipal elections and the rising of Parliament on the 10th of September 2021. And then the process was reconvened in November of 2021. During the NCOP process, provincial legislatures provided negotiating mandates, and an e-list of amendments was produced by state and parliamentary law advisors in collaboration with our department, and final mandates resulted in the F bill being adopted by the Select Committee. An adopted bill was referred back now to the National Assembly in December of 2021. So now having a look at the main amendments that were proposed during this process, which are reflected in the F bill, and I'm going to summarize those. So clarification around certain definitions was also made, such as to the definition of audit, mitigate, and rehabilitate, only apply to Section 24P and Section 24PA. They omitted definitions for residual environmental impact and remediate. The definition for financial provision was further amended, provided for further clarity on financial provisioning relating to matters and providing the details should be prescribed by regulation and adjusting certain definitions to align. There was also alignment of terminology throughout the bill, specifically on compliance and enforcement matters, and clarification is provided in respect of the environmental, mineral, and petroleum inspector's mandate and role. A definition for mining activity was inserted, and consequential amendments had to then be made. There was an expanding and strengthening of the NEMA principle to recognize and promote the full participation of previously disadvantaged professionals and Indigenous knowledge practitioners in environmental management sector. A definition for Indigenous knowledge practitioner was also inserted, replacing the term State Department with a wider term organ of state in relation to consultation on environmental authorization applications, and then correcting grammar, textual, and numbering errors throughout the bill. Then in relation to the Biodiversity Act, they further amended the well-being definition with consequential amendments required as a result of the proposed amended definition. They clarified consultation requirements for MECs by providing clear wording. In terms of the Air Quality Act, they further clarified the licensing authority mandate for air quality related matters where multiple local authorities could be the licensing authority. In relation to the Waste Act, they amended the definition of waste to allow the necessary clarity and addressing challenges that had been experienced with the current definition, as well as consequential amendments and a transitional provision in this respect. So in summary, and these are my last few slides, I know that it's quite a lengthy presentation, but in summary, the National Environmental Laws Amendment Bill will improve NEMA and the SEMAs. Amongst others, these are the main improvements that it is aimed at doing. So a new NEMA principle promoting diversity in the sector, the competencies of the various competent authorities and licensing authorities in terms of NEMA and the Air Quality Act are further clarified. The provisions relating to the integration of licensing processes and the issuing of integrated environmental authorizations for the purposes of the One Environmental System have been further strengthened. Clarity is provided in respect of what an environmental management instrument is. The bill provides clarity that successors in title on which an unlawful activity had been committed will now be able to lodge a Section 24G application for an environmental authorization or a waste management license. The provisions of Section 24G of NEMA and Section 22A of the Air Quality Act have further been strengthened and penalties have been increased. The legislative provisions relating to the financial provision for the purposes of progressive rehabilitation, decommissioning, closure, and post-closure for mining activities have been strengthened. General interpretation and implementation challenges in respect of enforcement are being addressed. The Minister has been empowered to prescribe the Code of Conduct for environmental management inspectors and environmental mineral and petroleum inspectors. Municipal managers can now issue those 28 directives for serious harm to the environment. All decisions made under delegated authority in terms of the Air Quality Act and the Integrated Coastal Management Act can now be appealed against in terms of Section 43 of NEMA. The scope of the Biodiversity Act will now include the consideration of the well-being of animals in the management, conservation, and sustainable use thereof. The concept of well-being has been defined, and the Minister has been empowered to make regulations or to prohibit certain activities that may negatively impact on animals. Clarity is provided on the definitions of control and eradicate, as well as on the measures to be undertaken to eradicate listed invasive species. There are provisions made for the constitution of a board for the Waste Management Bureau with explicit powers and functions. The waste definition has been substantively amended to address interpretation and implementation challenges. Residue deposit and stockpiles will in future be addressed under NEMA and not under the Waste Act. The Integrated Coastal Management Act has been amended to allow for the removal of illegal structures erected prior to the commencement of the Act. Section 48 of the Protected Areas Act has been amended to provide for a process and criteria to be considered when an application is lodged to conduct commercial prospecting, mining, exploration, production, or activities related to that within a protected environment. And also it enables the revocation and suspension of atmospheric emission licenses. Thank you, Honourable Chair. I know that that was quite a mouthful. We felt that we needed to take the committee through that in quite a lot of detail, and we do have the entire team available, for the purposes of taking any questions from the committee. Thank you.
Thank you, Ms. Craig. If you can remove the presentation from the screen, please.
I will do so.
Thank you, colleagues. Here we go. Can I see a show of hands for clarity? Seeking questions on the presentation. It will be Honorable Paulsen, followed by Honorable Phillips, then followed by Honorable Bryant. Over to you, Honorable Paulsen.
Thank you, Chairperson. Chairperson,
Can I plead with you that you put your video on? That's the directive from the Parliamentary. At least today you're properly dressed.
I'm wearing a Red Friday, Chairperson. It's not an EFF t-shirt. There's no
I can see that.
Okay. Chairperson, this bill is only part of the larger act, and I just wanted to know in terms of dealing with any issues around the enactment of any of these amendments, where are objections raised for people who have issues as to how the relevant authorities provide services in response to these issues? Is there an ombudsman who takes care of the environment? Who do they go to complain about government services that should be provided in terms of this bill, in terms of the entire act? If we could know who takes that responsibility, who exercises the oversight, is there an ombudsman, is there a commissioner for the environment? Thank you very much, Chairperson.
Thank you so much, Honorable Paulsen. Honorable Phillips, over to you.
Thank you very much, Chair. Sorry, the lighting is really bad here this morning. I have a number of questions, and most of them relate in slide 9, for instance, where we have the ability of the Director General and the municipal manager to issue Section 28.4 directives. What, again, going on to what Honourable Paulsen said, is what is the recourse if neither of them take any action? And then my concern is that in a lot of these amendments, the Minister of Minerals and Energy has actually been given a lot of power to act in an area that is actually the environment. And if we look at what happened with car ships and with the exploration of the coast now, with the 3D blasting, we can see that he hasn't always acted in the best interests of the environment, but in the best interests of mining. So I'm a little bit concerned about that. And then on the fine of 5 to 10 million, we just have had a huge coal spill, a spill where a coal slimes dam collapsed and spilt into the Mzanduzi River in Natal. And there's been litigation about that fine that was issued to those people years ago already. In some instances, for a huge company, a 10 million rand fine is a slap on the wrist. And I would rather look to having a percentage of their profits become the benchmark for how much they are fined. Because for a small company, 10 million isn't a huge amount, but for a big company, it's nothing. So to make it more even, I would really look at a percentage of turnover or income or profits. And then in section 48 on slide 19, protected areas were there for a reason. Now we can have permission granted, and it becomes a very slippery slide down into basically who can assert how much pressure on which particular area of governance to get that permission. I'm not very happy with that. Those protected areas were proclaimed for a reason in the first place. Slide 21, where they can appeal to a local council. Our local councils don't always have the expertise that we have at a national level. So I think that there should be a trail there where it can then be escalated onto a national level. Slide 24, we're going to legalize illegal operations. So does that mean that the zomas that are mining under the roads are going to be legalized? Where are we going to draw the line? And how is that actually going to be implemented without any further corruption creeping into that? And then with giving the municipal managers more power, that really concerns me, because in so many areas, the municipal manager only serves at the pleasure of the mayor and the ruling party. And they will then do whatever is in their best interests to carry on serving as a municipal manager, and not necessarily in the best interests of the environment, because it's only the mayor who at the end actually can take action against the municipal manager. So I'm very concerned about the insertion of that clause of the municipal manager. Thank you so much, Chair.
Thank you so much, Honorable Phillips. Can I hand over to Honorable Bryant?
Thank you very much, Chairperson. Good to see you. Chairperson, there are a couple of points that I want to raise. I think Honourable Phillips has covered one or two of them already, but the first question, just in terms of the timing around public participation with these amendments, I know there has been some concern raised amongst some sectors within the NGO community and other stakeholders to say that they perhaps haven't had enough time to properly consider these revised amendments. I just want to find out whether or not Ms. Craigie feels that process has been extensive enough, and if those individuals have been given enough time to comment. There are many aspects that I would be quite supportive of. The issues around animal well-being certainly must be commended in terms of those amendments. The definitions in terms of tightening definitions around waste and the environmental considerations around mining to be expanded on. I think those are also very commendable. There is a proposed change to the regulation that was proposed on the 31st of December to NEMLA, which is around appeals. And there is a lot of clarity being sought from members of the public and members within certain sectors as to how that will impact the ability of, shall we say, regular members of society from launching appeals. And that speaks around the clause that's been proposed, the proposed amendment to say that no person other than a registered environmental assessment practitioner may perform tasks in connection with an appeal contemplated in Section 43 of the Act. I just want to ask Ms. Craigie in terms of that, whether she has an opinion and whether or not that clause is going to have a negative impact on the ability of regular members of society from launching appeals effectively. Thank you.
Thank you so much, Honorable Grant. Inkosi Kumede, please, can you mute your microphone? Can I plead with all the attendees of this meeting to just do that and mute their microphone? Ms. Craig and the team, are you ready to respond to the issues as raised by colleagues?
Thank you very much, Chair. I heard the disclaimer that was made by the colleague from the State Law Advisor earlier, and as the DG mentioned, I'm standing in for the DDG of Regulatory Compliance today. I will therefore try and deal with some of the questions, but I really would then like to hand over to the Chief Director for Law Reform, Linda Garlip, afterwards, because I think she can really give the committee and share with the committee the details around some of these issues that I wasn't really involved with. So perhaps let me try and respond to some of the questions. Honourable Paulson, when it comes to an ombudsman for the environment, and there is not one that exists at the moment. It has not been raised as far as I know before. I know that we work quite closely, often with the South African Human Rights Commission, with a public protector. And so I think often in many cases where, the general public feels that perhaps the environmental authorities are not executing their mandate or are not doing what they should be doing, it is normally those two bodies that I'm aware of that those people would then approach. And they would obviously then investigate the way in which we are doing our work. I think when it comes then to Section 28.4 directives, I think the thinking was there, and Section 28 has been part of our legislation for a very long time. It is obviously linked to that duty of care that people must not, unlawfully, intentionally, or negligently cause significant harm to the environment. And obviously where that harm has been caused, we as authorities and as the DG specifically and the HODs within the provinces had the ability to issue a directive. And what is quite important within Section 28, and I'm just remembering off the top of my head now, I think it might be 28.12, if the DG or the HODs currently do not then issue those directives, a 28.12 notice can be issued to us, and they do come through on occasion where they feel we're not taking action. And what a 28.12 is the member of the public, attorneys, can then write to our department and say, we feel that there has been a contravention of the duty of care and that you should be issuing a directive. And that is normally a precursor then to them going to court to get an interdict. And so the 28.12 normally then, has the effect of getting that department to actually look at 28 and do their work. So the thinking around this amendment was really just to bring both the Minister of Mineral Resources and Energy, because of the One Environmental System, to give them more power. Remember, as part of the One Environmental System, they already have the power to issue environmental authorizations and in fact have the mandate to do so. And therefore they also have the ability through their mineral and petroleum inspectors to take compliance and enforcement action. And so this, to give the Mineral Resources Minister this power, or sorry, the DG this power, was to really give them an additional enforcement tool to be able to issue directives against those mines that are breaching their duty of care, and similarly to give the municipal manager those powers as well. When it comes to the fine amount, so the amendment in this bill is specifically increasing the maximum fine for a 24G fine. So we're not looking at the other fines that relate to other offences, but we're looking at a 24G fine, which is that fine where somebody starts illegally without an environmental authorization. They are then able to put in an application. We can consider that application, and very importantly, in terms of this amendment, we can obviously deny it. So we can say, as government, we don't agree that you can get authorization. But before we make that decision as to whether to authorize them after the fact, not to authorize them after the fact, to issue a directive, before that, we fine them. And there's already a process within the law to fine them. And what this amendment does is it's saying the maximum will no longer be 5 million, the maximum will be 10 million. But remember, there is always the possibility to not allow them authorization after that. And remember, there's also the possibility, in addition, to take them on through the criminal investigation process and also prosecute them for that. I'm going to leave the Protected Areas Act amendment to the DDG within our Biodiversity and Conservation section. She is with us. Also, with regard to the appeals section, I think Linda can come in on those issues. I think I would then maybe hand over, I think, to Linda to try and deal with some of the others, and I can also come back in if we've forgotten anything else. Thank you.
Good morning, honourable members and Honourable Chair. I will just take quickly just to say something about Section 48. Section 48 in the Protected Areas Act provides that there can be no mining within protected areas. The only place where the Minister, in concurrence with the Minister of Mineral Resources, and we have amended it in this bill, can consider mining is in a protected environment. And that is in the current Act as it stands. So in a protected area, normally, one cannot mine unless it is a protected environment where the Minister has a discretion. And what we have done in the bill is the bill just set certain criteria which needs to be considered when taking such a decision. And because the Minister of Mineral Resources already take the decision whether to issue environmental authorization or not in terms of the National Environmental Management Act, we have removed the concurrence with that minister. But of course, our minister still then need to consult the Minister of Mineral Resources before she make a decision. So we did not amend the Act in respect of whether mining can be allowed in protected areas or not. That is already regulated in the current legislation. In terms of the appeal to lodge to the municipal council or local council, municipal council, currently the decisions is taken by the municipality in terms of the Air Quality Act, and then there's an appeal process. But the current Air Quality Act doesn't make provision for an appeal process where the decision is taken by a municipality. So previously, they have used then the Municipal Systems Act to lodge the appeal, and the previous portfolio committee was of the view that there should be also appeal in terms of Section 43 of NEMLA in the case where the municipality take the decision, and that this decision will be then to the council. In terms of the publication of the notice on the 31st of December, it was actually unintended. Our administrative processes within the department just took far longer. It was never intended to be published on that date, but in the end it did happen, and we so it was published on the 31st of December. But what it was about, it is actually published for consultation purposes, and that is just to make some amendments to an existing regulation, and we call it a Section 24H regulations, which actually intends to professionalize the environmental assessment practitioner profession. One must remember that these professionals, they produce reports on which decisions are made by the various competent authorities. And it's very important that these reports one must be able to rely on them, and that must be good quality reports. In some of the provincial competent authority, the appeal authorities are dealt with technical people, and as part of the appeal, they also consider technical reports. They will consider the environmental impact assessment report. They will consider also the various specialists report. So they will do that sort of work. And the general view was at a time that maybe these appeal officials that also deal with appeals and advise the minister or the MECs or the consultants that do so as well, that they should also be registered EAPs. But the regulations that were, or amendment regulations that were published for public comment was very clear that we will follow a phase-in process, and that these, it was not intended that those that deal with appeals would then immediately need to register. So it's still currently open for public comment, and the department will consider all the comments received. Thank you, Chair.
Thank you so much. I see further hands. It's Honorable Weber, then will be followed by Honorable Bryant. In that order.
Thank you, Chair. Sorry if my car makes a noise. I'm driving. My apologies. I hope you can all hear me. Chair, I want to make a comment to the lady that just spoke, and I agree with her regarding the mines with the protected areas. But maybe we must change then Sunday or the biodiversity part, because we have many, many protected areas that is truly protected, but it's not certified. The farmer or the person who is in possession of the protected area, no, it is on the maps, but it is not registered by SANBI or the province. And we have dealt with it. And you know what? It takes 5 to 6 years to get an area protected. And in that 5-6 years, and I'm talking about serious protected areas, then the mining starts happening. So we need to give sort of maybe a time limit to the process of becoming a protected area. I'm not talking about people taking chances, but I really am talking about specific protected areas. And I don't know how we're going to deal with it, but I agree with Honorable Phillips. There is many mining actually happening in protected areas because that specific place has followed the procedures of coming protected and they're legal to do it, but the process is just too long. So a mine can do a lot of damage in 5-6 years to a protected area. So I do want to make that comment, just to maybe propose a timeline for Zambia or our provinces that's not underused to put a timeline towards the registration of these areas. Thank you very much.
Thank you, Honorable Weber. Honorable Brent, over to you.
Thank you very much, Chairperson, and thank you to the officials for the responses. I didn't catch the name of the second official, but just in terms of the comments that were made, the responses, I know she said that the details were made quite clear. I think, unfortunately, when it came particularly to that one clause, it was a little bit unclear and perhaps a little bit ambiguous. And I think that's led to quite a lot of concern within the NGO community, within the community of people who are very passionate about appealing certain environmental rulings and standing up for the environment, who are concerned that they might be excluded from that process. And I think perhaps clarity can be provided now in this meeting, at least, specifically in terms of where it says registered environmental practitioner may perform tasks in connection with those appeals. Perform tasks, is that referring only to tasks related to the minister and government itself? Or are we talking in terms of tasks such as part of your appeal? If you are appealing as a general member of the public, you have to be a registered environmental practitioner. And I think that is the issue of clarity that a lot of people are struggling with in terms of their own interpretation. So I think there is ambiguity there, and I think perhaps that's one of the reasons why, and we'll only get to that obviously at the end of these deliberations, why I think we may need to refer this for further mediation. But that's the one aspect. And just in terms of the other one, I understand that the comment period's been extended, I think, until the 21st of February. Can you just confirm that has taken place, so that there is still a further opportunity for members of the public to make comment? Thank you.
Thank you, honorable colleague. Then I should think it seems like these amendments by the NCOP strengthen the bill generally. And as a department, I think you appear to be happy because I don't hear you saying with these amendments, what's your take, DG? And then the other issue I've heard, Honorable Phillips talking about the fine that must be considered. I think we should do that. Then when we do that, it must be against the original fine. Maybe you can then expand a bit that one on the fine issue. And then it's our understanding that protected environment is managed less stringently than protected areas. And I should think this is trying to explain that these are different things. Maybe as a department, for the benefit of Honorable Phillips, can you then expand or explain the difference in relation to allowing mining activities? Because we don't want the situation we're in terms of these amendments, then we're going to leave being confused on the two forms of area, the protected areas versus the protected environment. So this is what one feels you need to also attend to it. Then Honorable Weber, is it a new hand? Follow up before I allow the department to respond, or it's an old hand?
Sorry, Chair, it's an old hand.
Okay, thank you. Over to you, Team DFFE.
Thanks very much, members. I wonder whether, Linda, do you want to come back in on the issue around the appeal? Because I think you are the best place to deal with that issue. Maybe let me expand a little bit in relation to the fine. So the fines, the increase of the fine from 5 million to 10 million, as I said, is really linked to a 24G process. And I know that Honorable Phillips, I think it was, who mentioned the fact that can we not rather link it to a percentage of profits? I think the difficulty with these, specifically these 24G fines, is they are linked to the listed activities that obviously are in our EIA legislation. And so sometimes they are done by an individual person, sometimes it's done by a company. And so the thinking at the last round of comments that went into increasing it at least from 5 million to 10 million would then allow for a larger fine to go against companies, but obviously there's still that range. And so we have a very specific fining committee that sits within our department and sits within the provincial departments and actually uses a calculator that guides them in terms of what the fine should be for a particular 24G application. So this isn't the fine that is linked to a criminal process. It is specifically the fine that is linked to a 24G process. And so that was the thinking as it went through the committee into the NCOP, was to say, let's at least raise it to a level of 10 million rather than 5 million, knowing that even in those cases, they may pay a fine and we might actually deny them authorization, which might actually be the bigger impact on those industries. But I think as we move potentially into a new amendment, because I think we may be starting to work on a new NEMLA bill, perhaps what we can do is really start having a look. One of the issues that is coming out of our department currently, and we're busy with a policy at the moment, is a policy around administrative fines more generally for environmental legislation. And I think that's something we can look at then in terms of that policy. And obviously, once that process is finalized, we would bring that through to the portfolio committee as part of the legislative review process, and these types of issues could potentially be incorporated into that process. But let me hand over to Linda, and then perhaps one of the officials from BNC, or perhaps Linda herself, could just talk to the issue around a protected area versus a protected environment. I'm not sure, Dr. Fisher, whether that's something you might want to come in on. Thanks, Linda. Maybe you next, and then followed by the other officials.
Thank you, Francis. Honourable members, maybe I can just explain quickly in terms of Section 4, in terms of the protected areas. A protected environment is normally an area that is around a protected area and it's a buffer zone, or where you intend to declare an area as a protected area, then one can also first declare it as a protected environment. So there's specific provisions in the Act to make provision for its declaration. Then the second question was, I need to stress that a Section 24H regulation amendments doesn't relate to the bill. So it is a separate issue. And we have agreed to extend the comment period to 21 February. And I must agree, after we have received the public comment, if we retain the clause on appeal, or a regulation on appeals, then we definitely need to break it down to activities, but as I said, we are still receiving comments, and we will consider that. Normally after we have received the comments, we also prepare a comments and response report. So breaking the other activities where we did break it down in activities, we haven't received so many comments. So I do think definitely if that is retained, that would assist to address the public comment. And then I forgot to actually address the committee on the public participation process. As Ms. Craigie explained, prior to the parliamentary process, the department, after Cabinet, we normally do a public participation process, and then each House of Parliament also do its own public participation processes. But unfortunately, we cannot comment whether Parliament's public participation processes were adequate or not. That is for Parliament to decide. But we have done, there are 3 opportunities on a bill for the public to comment on bills as it moves through the various processes. And that is all from my side.
Ms. Craig, have you responded to all the issues as raised by members?
I hope so, Chair. I have checked my notes and I think so. I think there was just one.
My issue of whether you are happy with the amendments by the NCOP remains unattended.
Yes, I want to say yes, but I see my DG's hand is up, so I'm going to hand over to her. Thank you.
No, thanks. Thank you, Chair. I thought I was going to come in at the end after the other responses. Generally, Chair, as a department, and already as alluded to by Ms. Craig, we have been involved throughout the process of the amendments. And also we have been engaging at NCOP level, select committee. And what I want to confirm to the portfolio committee is that generally we are in agreement as a department with the amendments that are being highlighted. Obviously, I think there's the aspects of the points that are made by the committee, of which then will be directed at the end of the meeting around what the committee resolves. Thank you, Chair.
Okay. Colleagues, there's no follow-up. Are we then adequately covered? It looks like we've disposed out of this item. And then coming to the earlier proposal by Honorable Person, I don't see any need based on the explanation that we need to then call our counterparts for clarity. And then I've deliberately asked the question whether the department was happy with the amendment. From where I'm seated, I should think then the NCOP succeeded in strengthening the bill as it was before. Then I need to be guided by the members, the proposals, whether we should then table back the bill to the NA for the president to assent it for it to become law. Having understood what Ms. Craig was saying, then there will be future amendments that will be coming as well. Can I get a mover and the seconder to that effect? I see Honorable Mchunu's hand is up.
Thank you, Chair.
Yes.
Thank you, Chair. I move that we take the bill to the NA for the necessary. I think the officials have given enough explanation. Thank you, Chair. No.
There's a mover. Honorable Bryant, your hand is up.
Thank you, Chairperson. Chairperson, I would make a counter proposal, counter move that we refer the matter to the mediation committee as also given as an option by the legal practitioner at the beginning. And I would just say that my two colleagues on this meeting would be in agreement. So that's our position. Thank you, Chairperson.
Okay. It's a counter proposal, colleagues. And we are amenable to persuasions. Maybe Honorable Bryant, if you can follow up and explain to us the issues that you think they need to be referred for mediation. Maybe we can be persuaded. Can I give you that opportunity to do that? What are the reasons?
Thank you, Chairperson. Chairperson, I think my colleague, Honourable Phillips, has raised a number of issues that required further clarity, and I think some of those are still outstanding. I don't think they've all been adequately addressed. And I do also think the time frame around the lengthy process that has been undertaken, falling between two different administrations, also has a bearing on the efficacy of these amendments and whether they've been properly and fully contemplated. I would also like to give, if possible, Chairperson, my counterpart, Honourable Phillips, an opportunity also to speak. And I'm also happy to hear the opposing side as well. Thank you, Chair.
Yes. Honourable Phillips.
Thank you very much, Chair. Yeah, I'm also very concerned about the fact that it falls between two administrations, and we never actually had opportunity to get the bill presented to us, the amendments presented to us, and we are not privy to what the debates were in the previous in the previous administration. So I'm very reluctant to just go ahead and say, let's approve them, especially in light of the fact that there is going to now be new amendments drawn up. So it looks like we're actually going to be agreeing to amendments that are or could possibly be obsolete. So for that reason, I think it would be wise for us to take it on review. Thank you.
Okay. Honourable Mchun, your hand is up.
Thank you, Chair. I hear my colleagues, they are saying that we need to take it for further, but given the when understanding the explanations, and yes, we are all disadvantaged that we are not part of the portfolio committee at that time. But now that they've explained and presented all the details that were there, although we're not part of the debate, but one is understanding that the bill needs to be processed, and the explanation, because the issue of intergovernmental challenges that has been explained, well, there is always a framework of dealing with those intergovernmental challenges, and we can't then say we refer the bill because we're not part of it. And the other thing, Honourable Chair, is that we have a problem with my problem is that we will keep on delaying the bill with just because we're not part of it, whereas the work of the fifth administration is a continuation. It's always continuous. We were all represented there, although they were not part. It was not physically the current members that were part of those debates. So it will be. It will be. It's for me. It's advisable that we allow the bill to go back to the NA, because the questions, the areas that were questionable are being covered. So, Chair, can we then go to the bill, and if there are any specific matters that the members still question, they question them, and we debate them further, because this is where we are, and this is where we need to move forward as the portfolio committee. Thank you. If there are any matters, that's my also proposal, Chair, that we debate further. They present where they are uncomfortable, because I thought Honorable Phillips was saying there are areas for them that they are not comfortable with. Can we get those specific areas so that we zoom into those areas with the department and the officials? Thank you.
That's fair enough. And remember, today we're just considering the bill. Procedurally, we'll have to get a report at the end of the day that will then carry all these views to support what you were saying, Honorable Mkunu. And then we'll then deliberate on the report, and then we'll have to decide, all of us jointly. But I think the way you put it, Honorable Mdise, it assists. Honorable Mdise, I wanted to say Honorable Mchunu. Honorable Mdise, your hand is up.
Yes, Chair. Thank you very much. Chair, I sense that there are, well, I do not sense, I hear Honorable Phillips and I think Honorable Brian, they think that there are areas of discomfort, and there are inputs that they would still want to make to this discussion and bill. And in my view, this bill is still open until the 21st of February. Point one, I think because that process is still open, honorable members have a right to make an input on the issues that they think are left out. But in my view, because we are at this level now, why don't we just engage and rekindle the areas of discomfort and the areas of disagreement and discuss how do we move forward beyond that? Thank
you. Okay. Honorable Gancho, welcome. You came back earlier to the meeting. You've been here for quite some time.
Thank you.
Yes, I should have done that. My apologies.
Thank you, Chairperson. I just also want to add to what the Comrade Modise and Mkunu has proposed, that we allow more improvements on this.
Honorable Modise and Honorable Mkunu, not comrades.
Oh, sorry, Chairperson. Honorable Mkunu and Honorable Modise. I would like to also support their proposal that we engage more on these issues, and if it needs us to park this bill and reconvene again so that we can iron out whatever discomforts that we have, then I would advise that we do so. Thank you so much. My apology for using the term that is not allowed.
Yes, there we are, colleagues. There we are, colleagues. There's a view that this matter must be sent for mediation, but then we'd like the colleagues to tell us which areas in particular, because the department has been here to respond to some of the concerns. But at the same time, Honorable Weber, is your hand up?
Yes, Jay, it is. My apologies.
Yeah. Okay.
My speech, Jay. Thank you, Jay.
I hope you want to proceed to motivate the proposal for mediation. Proceed.
Jay, my question to you is, I agree we can go further and talking about the things, but if we can't resolve it by the end of the day, the possibility of then go to mediation, is that out of place? I know we can still change things until the 21st of February. The opportunity to go to mediation if we're not happy, will it still be there, or is today the final decision? And if it's the final decision, I will support my colleagues in asking to go for a review. But if there's time and another opportunity, if there's no happiness or anything, and we can then decide to go review, I would like some clarity on that one, please.
I wonder who's gonna respond to that on the mediation. Is the legal guys are still available? Because where we are now, we have got two conflicting different proposals. And then for us to move forward, we need to, if we can't find consensus, we are definitely going to then do the other way in this matter. But I should think we need to persuade each other on the matter. And we're going to do that, the issue of taking a decision once the report is tabled. Remember, the Secretariat still needs to go and do the minutes and do the report of these proceedings. That's when we are going to take a decision. But also taking the legal opinion, not looking at it one-sided, because it gave us options. And then there are those who feel, let's then go the mediation route. There are those who feel, let's then put the recommendation of the department that these laws, there are still more that going to be amended. And then for the department and all relevant stakeholders to move forward, they need this amendment. There's somebody who's, let me check with this person who's disrupting. Can somebody help me with the person? Is it you, Paulson? No.
Sorry.
Yes. Can we? So there's still more opportunity for us to process more amendments to address all those other issues that could be of concern. So we can then say, under the circumstances, the report that the Secretariat will bring, that will come for consideration, will be having all those divergent views that we're having now. And then at that time, that's when we're going to take a decision, because today we were just listening to the presentation, the tabling. There has to be the report. That's how procedurally these things are done. That's where we're going to do that. But then the DG send is up before I allow Honorable Bryant. DG?
Thanks. Thank you, Chair. I just thought maybe we need to clarify, because there's one concern that Honorable Bryant raises around the registration of EAPs, where we have published those registration at the end of December. What I want to clarify is that what we published are regulations. So that is not part of the bill. So it's different processes. So the regulations we have published for public comment. And one understands and hears that he is raising concerns and potentially other stakeholders are raising concerns. That's the one where we have opened it up until the 21st for comment. Those are regulations. So it doesn't affect, I just wanted to clarify that it doesn't affect the bill. Maybe other concerns will affect, but the one on section 24 is not necessarily in this bill. Thank you, Chair.
Okay. Honorable Bryant? Your hand is up.
Yes, thank you very much, Chairperson, and thank you to the DG for that clarity. I think there is a lot of confusion at the moment around those two different aspects, and thank you for clearing that up. I did get that earlier as well from the officials, but I know that my colleague Honourable Phillips does have one or two concerns that she would like to raise now, and perhaps if those concerns can be adequately addressed, and perhaps if we can get some information from the legal advisor in terms of the process of the mediation committee and what the potential delay would be to further delay to the bill. I think that would also be quite enlightening and help us to make a decision from our side. So, if possible, I'd like to let my colleague, Honourable Phillips, just raise her further concerns. And if I could ask as well, Chairperson, if our legal representative could expand on the process of the mediation committee in terms of how long that would take and what the process would be if we were to go that route. Thank you.
Honourable Phillips, your colleague says you've got issues to raise.
Thank you, Chair. The main issue is one I've already raised, and that's about the power that the Minister of the DMRE has on decisions that actually affect the environment. He's got a focus on getting in mining and getting new exploration and getting investment and getting jobs. And it seems to be that at the moment that is the top and only priority for him. So I would very much like to see that the Department of Environment has an overriding authority on these decisions that are taken by the DMRE, so that we are tasked with looking after the environment, but we can't do it if we've got somebody who can make decisions about the environment for us and not be taking the environment into consideration. So that is my biggest challenge at the moment. I mean, even if we look at the disasters that have happened at Engen and the other refineries, decisions taken there were taken by the DMRE, but they affected our environment, and it was our committee that was left with the issue afterwards, and we were left to pick up the pieces. And I don't see it applying to any other ministry where they have got the power to cause harm to the environment like the DMRE has, and that power is acknowledged in the amendments that we are making. So that's my real concern, is that we are actually rendered toothless by the DMRE.
Colleagues, but what we were here for the purpose of today was to deal with the amendments as affected by the NCOP. And these other new things that are outside the scope of the amendments, I think these are new matters. That's how I read this, in line with the legal, in line with the legal opinion that we got here, because we all agree. There's no one who's saying let's call the other house. Here, what was to do was to consider the amendment as made by the what you call it, by the NCOP. So we all agree that the NCOP has passed an amended bill in terms of Section 676 of the Constitution. And our options, as we are saying, which is to pass the amended bill or to refer it to the mediation committee for a decision within 30 days, which the colleagues are proposing, Honorable Bryant, supported by Honorable Weber and Honorable Phillips. But then, under the circumstances, it means then we have got two divergent. What I also hear, what the proposal is by Honorable Bryant, seemingly then the processes of the mediation, you further saying we need the legal advice to come and explain to us the mediation processes here. And then there's the view that you say, we agree with the amendments. Let's then take this report to the Assembly so that then the amended bill then is approved by the Assembly. And at that time, when we do that, there's a time for a debate and whatever. But now, procedurally, what we need to do here is I want us to close this matter because is Mr. Mjikela still here in our midst? Are you still here?
No, Chair, he requested to be excused. I was trying to call him, but he's not answering yet.
I think the colleagues who are proposing for mediation can at their own time now and until we adopt the report, ask for further details on this mediation process. But I should think then we need to I'll allow you, Honorable Phelps, to close on this matter that there are two views here. The other view is saying let's submit the amendment by the NCOP to the House. The other view is saying let's take the matter for mediation. So, Honorable Phillips, you wanted to respond to something before we conclude on this matter?
Yes, please. I just like clarity on slide 9. The third point, it says empower the minister to prescribe a code of conduct. I'd just like to know that minister referred to, is that the Minister of Environmental Affairs or the DMRE minister?
Okay, we're getting somewhere now. DG and Tim, can you respond to that?
Thank you, Chair. I'm going to request Francis to deal with that matter. Thank you.
Thank you very much. The code of conduct is definitely for our minister to set out that code of conduct. Remember, the environmental, mineral and resource inspectors have the same powers as our EMIs. So what we're wanting to do is ensure consistency across the sector. And so the minister would then, our minister, would be able to put in place a code of conduct for all of those inspectors. I think, Chair, while I have the floor, just to indicate one of the very important amendments that is in here that I didn't talk to earlier was we've actually amended through this process what we call Section 31D. Now, remember what 31D used to say is it used to say if, for example, a complainant ultimately wants to get the EMIs from the environmental departments involved in matters that relate to mining, what needed to happen is there needed to be consultation with the DMRE minister. So at the moment, the way the legislation is written, it says in consultation with, which means what happens is our minister writes to the DMRE minister, and if we don't get a response back and them agreeing that we can get involved, then we can't get involved. But what this amendment bill does is it changes to in consultation with to after consultation with. So we're actually strengthening the power of the environmental authority. So now what happens is our minister writes to the DMR minister, but even if we don't get a response back, then we can, as EMIs, get involved in some of those damaging activities from the mine. So there's actually very good amendments that are in here that will allow us additional power as environmental authorities. Thank you, Chair.
Thank you so much. Honorable Phillips, your hand is up again. Does it?
Yeah. Thank you, Chair. I would just like to then just ask that the in the preamble that I don't know how to do it in legalese because that's not my forte, but that unless otherwise stated, the minister in these regulations would refer to the Minister of Environmental Affairs and not to any other minister.
Response from the department on the follow-up question, DG.
Thank you, Chair. I think that clarification is something that can be looked into. Obviously, our legal people working together with the parliamentary legal team. So, yeah, I think it's something that we can refer to the team on whether it can be looked into so that it's clarified and it's quite explicit.
Okay. I should think then we exhausted all the issues they will have to schedule a meeting for us to consider the report of the outcome of this meeting. And then we are moving with the two proposals. The other one to say, let's submit the, oh, you still want to say something before I conclude? Honorable Bryant?
Yes, thank you, Chairperson. Chairperson, my main concerns have been addressed. I know Honourable Phillips raised those other issues, which I think have been addressed to an extent. But I think there's just a question around the specific wording that was just mentioned now. And perhaps if that specific wording can be amended, we could I think we would have consensus then from our side that we would be happy to go with the original recommendation from Honourable Nkunu. Thank you.
Okay, we're getting somewhere. That's why we have this power to persuade each other. DG, can you deal with that as raised by Honourable Branch?
Thank you, Chair. Can I request Linda to come through in terms of clarifying, because I think also when you go through the actual bill and even the NEMA Act, those specifics are also there. But let me give Linda to just as a legal official to provide an appropriate answer, Chair. Thanks.
Linda, over to you.
Thank you, Honourable Chair and honourable members. The various ministers' powers in terms of the Act is very clearly spelled out. There is, for lawyers, there are no confusion because this bill deals with 3 different ministers, and the 3 different ministers' powers are very clearly spelled out. Maybe it doesn't come out in an amendment bill because we have to read it together with the Act.
It's like it's complicating matters. Honourable Phillips?
Thank you, Chair. If that is the case, then I am happy to go with the recommendation as put forward by yourself and agreed to by my colleague Dave Bright.
Wow. This is what we do, the power of persuading each other. Yeah, the difficulty I understand of your colleagues because we're not the originator of this bill. And then it means then it's now high time that we then prioritize this work of us legislating until we wait towards the end of the term. And nothing bars also the committee from starting to initiate legislation than to wait for the executive. Maybe that brings me to the issue that maybe at some point we need to just have a session as a committee to look at all these bills and legislations and look at some of the things that we cannot initiate ourselves than to wait to the executive. But I must say, I'm so impressed, colleagues, our capability to persuade each other, the matter get resolved, that we're going to move along this line as long as we make sure that we do oversight. And if there's a situation we're seeing a minister who's overstepping his or her powers and roles, I think it's within our rights as the legislature to call that minister to order and call that minister to come and account to us as the main committee that is well placed with this environmental legislation. I think I must thank you, colleagues. Thank you for persuading each other. And I understand your concerns as well. To say this is not something that we started with then. That's where we find ourselves. But that clarity, I think something then, one is to thank all of you for this, the ability to persuade each other. That's how thriving our democracy is. Thank you so much, colleagues. I should think then, okay, Honorable Bryant, you want to say something again? Yes. proceed.
Chair, I just want to say thank you to you for dealing with this in such a sensitive matter, so that we're all able to have our opinions and our say, and we would then go with the proposal as set out by Honourable Mkunu, taking into consideration the concerns that have been raised. We certainly don't want to get in the way of the legislative process. We know we have a lot of legislation that still needs to get passed through, but we obviously just want to make sure that the concerns are taken into consideration. Thank you, Chairperson.
Thank you so much, Honorable Brand. And then when we deliberate, the beauty about it as well, there's an opportunity to go when we deliberate on the bill in the assembly, when we debate, then we can also raise all our concerns, dissatisfaction, so that then the message goes across to whoever has to receive that, to say, if it's the law must be implemented to the letter. But they should. Thank you. Then can we take a 5 minutes comfort break while the department then put on the other presentation on the other bill, that this is our bill, which we must all now focus on and make sure that it get processed. It shouldn't lapse. It shouldn't take 5 years for it to come back. We must make sure that this bill, by the time our term comes to an end, it must have become the law. So let's then have 10 minutes comfort break. It's 10:47. It means we're going to reconvene at 10:57. Thank you so much. We'll await the report. We'll await the report, which we'll then finally adopt in the next meeting. The colleagues on this on the previous item. 10:57. 11:57. We shall be back. Thank you so much, colleagues.
In terms of the National Forests Act, this act was promulgated about 24 years ago with the main purpose of promoting sustainable management and the development of forests in the country, to also provide for protection of certain trees and forests. It also goes on and look at how the different communities or different sectors within, subsectors within the sector can benefit in terms of forestry development. So the principal act itself has the first chapter that deals with the definitions, and then it has a chapter that deals with special measures to protect the forests, and the chapter that deals with the use of forests. Another one that deals with the different institutions that are established, mainly the National Forest Advisory Council that advises the minister on different issues. And then chapter 6 deals with the administration, chapter 7 with the offenses and penalties, and then chapter 8 deals with enforcement. So in terms of the amendments that were commenced a while back, what we wanted to do was to provide clear definitions of the terms. This was mainly to just make sure that in terms of enforcement and compliance, it is easy to do that. And also when we have some cases to deal with, it is easy to ensure that whatever we are trying to do is understandable. The second issue was to make sure that there is increased promotion of enforcement and in terms of sustainable forest management. Also, we wanted to deal with measures to control or remedy deforestation, because this is one of the issues that we struggle with as a country, and also to deal with the appeal procedures. The Principal Act did not have this, so one of the amendments was to make sure that we have an appeal process that can be used by the members of the public should they want to appeal any issue in relation to the work that we do. And then lastly was to just make sure that there is inclusion in terms of equity in the participation of the council that advises the minister, especially with regards to participation of women and youth. So the amendment bill was passed by the National Assembly in August of 2018, and then it was referred to the National Council of Provinces for concurrence. And the work started at the beginning of 2019, but then due to the changes and the commencement of the 5th Parliament, there were some delays. And then the Select Committee then took a decision that they needed to consult further on the proposed amendments, just to make sure that they've included stakeholders in the different provinces. So those consultations and public hearings were done virtually at the time due to COVID, and this happened between June and October of 2020. And then following those public hearings, then the provincial legislatures had discussions and presented to the Select Committee their reports, and then that commenced with the debate and passing of some of the clauses. And then that happened during June, and then there were some reports that came out of those discussions that necessitated that the department and the chief state law advisors and the parliamentary legal advisors needed to have a discussion and consult on some of the issues that were raised, and then a C list was then developed. And that was the C list then that was used by the Select Committee for their discussion and their voting. And then this led to the Select Committee debating and passing this D list, which then was presented to the NCOP for debate, and then it was passed and referred now back to the National Assembly for concurrence. So, Chair and honorable members, what we are going to specifically look at here today is the additional proposals that the process of the NCOP proposed. So in terms of the definitions that we had proposed, those were accepted. And then the NCOP added a new proposal because they felt that there's a need that we also define what a destruction of a natural forest would mean. Because we are talking a lot about that in the Principal Act, where we're saying you are not allowed to destruct a natural forest. So we needed that definition. And that definition is as follows: that it is any action where one or more trees in a natural forest is felled or is caused to die, or the undergrowth is removed for the purpose of land use or resource use. So this definition was then accepted and by the select committee and was also passed by the NCOP. Then another definition was the one on new land use, which would mean that it's any activity leading to the use of land, which would require the removal of natural forest, which is not restricted to land uses requiring land use approval, zoning, or rezoning. So this proposal, as well as per the debates by the select committee, was then accepted and was also passed by the NCOP. Then the third amendment in terms of the definitions, we had proposed a definition for woodlands, and then the select committee and the NCOP then felt that there is a need to strengthen this definition and added Part B on the original one, where a woodland would have now two portions. The first portion would be a group of indigenous trees, which are not natural forests, but whose crowns cover at least 5% of the area they occupy, and which may, in a degraded state, have a crown of less than 5%. And then the addition or the additional input was that the Part B would then be any vegetation type declared by the minister to be a woodland by notice in the Gazette, so that it covers all the woodlands that have been declared and woodlands that could be declared in the future by the minister. And this was also accepted by the NCOP. Then in one of our proposals, we had proposed that we amend section 16(1)(b) and include a wording or that would say, that would be an addition saying, or a state forest or a part of it, which would then also refer to section 18(1). Now in this, this clause was then rejected by the NCOP because they felt that the Principal Act is clear enough. There is no need for us to really amend that section. And then in section 23, here we wanted to have an amendment where we were proposing that in terms of the work that can be done by companies or by people that have permits in the state forest, where we are saying that no person may engage in any prospecting or mining activity in a state forest, except in terms of an existing lease agreement or any other valid contract or applicable legislation. So the emphasis that was included by the NCOP was that when we talk about the existing lease agreement, be specific that it would relate to mine gravel or sand for road maintenance. This would then allow for the companies who are managing forests, because they will need to make sure that their roads are, are worthy of being used, especially that they would need to fight fires or transport timber. So for them to maintain the roads, they needed to have at least that permission for them to mine for gravel or for sand. And this was then accepted by the NCOP. And then with regards to the council that advises the minister on forestry matters in the Republic, we had initially had an amendment, Part J, that would then also include youth and women as part of the people that must be considered for this council. And then the NCOP through the select committee then included that we should also make sure that it's youth, women, and persons with disabilities, just to make sure that everyone or all the previously disadvantaged persons are included. And this was accepted by the NCOP and was passed. Chair, I think in terms of the deal list that we have, this is all we have on this amendment bill. Thank you very much.
Thank you so much, DDG. Colleagues, are the issues that we want to raise with the presentation by the DDG? Colleagues, are we still there? Yes.
I'm
here, Chair.
I wanted to understand that. Now I can see hands coming. There's Paulson, there's Bryant, in that order for now.
Thank you, Chair. I just wanted to make a comment that...
What's wrong? What is the background there?
Sorry, Chair. I just wanted to make a comment that there's no real issues. It's fairly self-explanatory, the amendments.
Where are you?
Me?
With that nice shirt of yours.
Right here, Chair. Right here in Parliament. See there? The building is...
Okay, proceed.
No,
What
Chair,
were you saying?
Chair, I just wanted to make a comment that the amendments are fairly self-explanatory. Thank you very much.
Okay. Honorable Bryant, over to you.
Thanks very much, Chairperson. Chairperson, it's just in terms of slide 9, where they speak around the new definition of woodlands. I'm trying to work out where a fynbos biome, fynbos forest would fit in terms of the protection of a natural forest. Is this falling in a different piece of legislation, or would this be covered under the new definitions? Because obviously we have very, very important fynbos in particularly down in the Western Cape, other parts of the country as well, that require additional protection and preservation, and also often bordering state forests. I think in particular the Table Mountain National Park, for instance. So I just want to find out in terms of those definitions. Thanks.
Thank you so much, dear colleague. And then from my side, because I don't see any other hands, unless if, oh yeah, it was Honorable Bryant. There are issues that one want to understand quickly. As one goes through the memorandum of the objectives of the bill, it is stated that financial implications of the bill are none. What does this financial implication refer to? Because at some point we understand that the bill has to be costed, and definitely when there should be resources that are required to implement that act, should it become law. And then maybe clarity when I am asking, when you're saying there are no financial implication, are you referring to the cost of formulation and processing of the bill? I want you to clarify this, DTG. And then the other issue that one wants clarity on is whether yourself as a department actually conduct formal likely cost estimate for the proposed legislation to determine the impact on government fiscus, because every policy, every legislation that you do has got a financial implication in either way. And then, because I'm raising it whether you do that or do you just introduce legislation obvious to the cost on the state coffers, such that at the end of the day, I've had experience in my other life to say that where legislations cannot be implemented due to lack of resources. When you ask people on the state of the readiness of the implementation, they say, we'll need so much, we're still going to, because it's very critical. That's why you even have to take the bill through regulatory impact assessment solely for that issue, to also deal with the cost issues. Then the other issue, I'm raising this because this could be the reason why we are known as having some of the best policies, yet many of these policies are not holistically implemented, because we realize at the end that there aren't simply enough resources for proper implementation. And then the other issue that one wants to get clarity on is whether these amendments that we're making to our fire-related legislation, including but not limited to the National Veld and Forest Fire Amendment Bill, consider climate change or contribute to the Vision 2030 of transition to a low carbon resilient economy and just society as espoused in the National Development Plan. Because definitely there has to be a link. I want to understand whether is this an aspect in the current amendment, because whatever we do, we should be guided by that to say we're living in a very difficult, in a climate change environment. And then while reviewing the state of the woodlands in South Africa in the late 1990s and early 2000s, it emerged that South African National Defence Force own substantial tracts of land that constituted woodlands. And then the question that I want to understand from you as the department, are they, the South African National Defence Force, part of those organs of state which are being compelled to join the fire protection associations? And if not, why? So those are my issues that I felt we need to raise with your good self on this one. Over to you, DG and team.
Thank you, Chair. I'm going to request the acting DDG to respond to the specific issues. Thanks, Chair.
Thank you, DG. And thank you, Honorable Chair and members for the questions. And thank you also to Honorable Paulson for the comment. In terms of the issue that was raised by Honorable Bryant, the National Forest Act, the way it is structured is such that it defines forests in three forms. There are forests that are your plantation forests. There are forests that are the woodlands. And then there are forests that are what we call natural forests. So all the forests that are often natural in nature, that are South African indigenous forests, are already protected by the Act. So in those instances, you then get the Act saying that you are not allowed to cut, you are not allowed to disturb, and all of those things, because there's that initial overall protection that is there for all the natural forests. Then in addition to that, we would then have additional protection, like declaring a certain area as a woodland, or declaring it to sort of enforce or to strengthen the protection, just to make sure that there is those additional protection that happens. Now, in terms of plantation forests as well, they are required to make sure that they take care of all the areas around them. For instance, you would have what they would call conservation areas within your plantation, because for the permits and the certificates that they get for them to be able to trade, especially internationally, then that certification looks at those things as well, that you must make sure that you take care of the areas around you. And also we also make sure that the issues related to NEMA, issues related to CARA are also taken into consideration when managing this forest. Then, Honorable Chair, in terms of issues related to the finances, what we are saying here is that there is funding available for the implementation of the Act currently. And the amendments that we are doing will not have additional burden in terms of what we want to amend. Just to make an example, one of the amendments deals with, let me just make two. One deals with the inclusion of women and youth in terms of participation in the council that advises the minister. That council already has funding for it to function. So we're just making sure that when nominations and selection is done, we are aware that those people need to participate. Another example would be in terms of protected trees. What is happening currently is that we would, on an annual basis, gazette the protected trees. But now one of the amendments is saying if there are no changes in the protected trees that are in the list, we don't have to gazette it again, because the gazette that would have been done in that particular year would not need any additional amendments, or would not have changed. So what we are saying is that there is funding for the amendments that are there in terms of what we are implementing right now. Then in terms of the issues related to the Fire Act, which is the act we're going to present after this one, Chairperson, you are correct. In terms of fires, there is a need to make sure that we are aligned to the impacts of climate change, because there's a lot of changes that are happening, and these changes do affect the intensity and the frequency of the fires. Hence, we would want to amend that legislation. And then also in terms of the SANDF, yes, they are part of the group that we would want to make sure that they are compelled to participate, because they own vast areas of land, and these areas are usually susceptible to these felt fires. Thank you.
Okay. Are there follow-ups from colleagues? If none, can I then ask the National Disaster Management Center to present I'm trying to check the attendees here. Do you have colleagues from the National Disaster Management Center? Yes. Chilek?
Hi, Jen.
Did you give them different times?
They were supposed to come, Chair, after lunch.
After lunch?
Yes, I thought we were going to finish at 1.
At 1. But I see the colleagues from the National House, they've been here.
This morning, yeah.
Are they all gone now? Huh?
There were some, Chair, that joined.
Okay, so it means we need to break for lunch.
Or we can take.
I see, and
those that are ready to present.
SALGA is here.
Yes, sir.
Maybe SALGA can do that so that it will give them an early. SALGA, are you ready, SALGA? Dora, Madam, are you ready to proceed?
Good afternoon, Chair and members. Yes, I think I'll say already. We were ready for after lunch, but we've been here, as you say. So yes. If our colleagues from NDMC are not yet ready, I've just notified our fire and fire specialist to join me. She was busy concluding a meeting, so I can start in the meantime.
Just introduce yourself properly for the benefit of members. I shouldn't assume they know you.
Yes.
I'm privileged to know you from my other life.
And thank you so much, Chair and members, as well as colleagues. My name is Dora Marema. I am the portfolio head for municipal sustainability at the South African Local Government Association. I have been tasked to represent SALGA in presenting the presentation. I want to believe that that the chair and the committee have been informed that SALGA doesn't have a political representative because we are in a period of transition.
Yes.
Thank you, Chair.
Okay.
I'm going to share my screen. Or is my presentation loaded?
Chileka, how have you
No,
you're giving it the sharing rights?
Yes, I just did, Chair.
Okay.
You can start sharing.
Okay.
Marema.
There we go. It's on the screen, Dora.
Yes. Thank you, Chair, again, and thank you for the opportunity for SALGA to be able to present on this on the National Veld and Fire Management Amendment Bill. What the presentation seeks to do is to provide our position on this amendment bill. I'm going to start just to give a bit of background. I'm trying to remove these things on my screen so that just in the form of background, we are just providing to members and the chair in terms of what the Constitution saying about the firefighting service, which is a constituted responsibility of local government. However, in terms of the Fire Brigade Services Act, Section 3, local authorities may establish and maintain a fire brigade service. Section 84 of the Local Government Municipal Structures Act deals with the division of functions and powers between district and local municipalities and provide that a district municipality has the following functions and powers in relation to firefighting services: planning, coordination, and regulation of fire services, specialized firefighting services such as mountain, veld, and chemical fire services, coordination of the standardization of infrastructure, vehicles, equipment, and procedures, and training of fire officers. This same act allocates the primary regulation and management of wildfires to district municipalities. Where local municipalities have institutional capacity, this responsibility has been delegated from the district municipality to the local municipality via a cooperation agreement. So in terms of the Fire Brigade Services Act, district and local municipalities are required to establish a firefighting service. The Act also provides for the minister to designate firefighting services as well. So further, it provides for the appointment of chief fire officer, the introduction of fees for the service, and the conclusion of agreements with other fire services so as to render a more efficient fire service. The white paper on fire services then repositions the fire services as well from a response-oriented fire services towards a fire risk reduction-based approach. This contributes to effectively integrated fire services by placing the fire safety and prevention, particularly community-based fire risk reduction, at the center of the fire services delivery, which will significantly contribute to the creation of safer communities as highlighted in the National Development Plan. So in 2020, in the year 2020-2021, financial year 2020-2021, SALGA conducted a study to determine the ability of municipalities across all municipal categories to perform function in relation to disaster risk management and fire services. And that the study reflected on effectiveness of the institutional arrangements, systems and procedures, and the ability of these systems and procedures to be able to respond, and the adequacy of funding arrangement, looking at various sources of funding. The study was literally a deep dive analysis through which a sample across municipal categories was drawn in order to arrive at an understanding of the challenges and the complexity of the provision of fire services and disaster risk management in local government. The study also reflected on the status of the legislative framework pertaining to these functions and elaborated on the challenges and solutions experienced by municipalities in executing the fire services function. In this study, SALGA, in consultation with its member municipalities, provides a rationale for the elevation of these services in municipal structures and argues for an increased allocation of resources and support at local government sphere for effective delivery of these services. Some of the findings of this study clearly indicates that currently there are many challenges and gaps in municipalities with regards to the performance of fire services. The white paper itself states clearly when it says that most of our fire services have made tremendous progress in delivering the various services that communities expect. The majority of our country's fire services are frankly not functioning properly and continue to grapple with serious challenges that over the years have weakened their ability to deliver on their legal mandate. The study also has identified, and the white paper also acknowledges, that the interpretation of Section 84(1)(j) of the Local Government Municipal Structures Act 1998 led to the complex and dissimilar division of fire functions between districts and local municipalities. As a result, in some areas, this has led to a two-tiered fire service provided by both districts and local municipalities in the same jurisdiction, often resulting in costly and wasteful duplication of efforts and resources. So just in terms of the implications of this amendment bill in front of us, SALGA believes that the amendments will definitely go a long way in encouraging local government to make bylaws, to implement and to put in place mitigation measures that ensure that all landowners comply with the provisions of the Act. However, with the background that I've given in the previous 3 slides, funding remains a key challenge for the municipalities to be able to perform this function, since the current equitable share received by municipalities does not seem to be adequate, and various proposals have been explored by all the parties concerned to be able to strengthen this function. There is an understanding that municipalities are already heavily constrained when it comes to income from rates and taxes, and since fire services is not defined as a basic service, it often results in a lack of financial resources allocated to function by municipalities. There is a need for support to improve the state of human capital and resourcing of municipalities for them to be able to enforce this Act. In terms of the implementation challenges of this Act, we just want to make a pronunciation that there is a clear, definitive link between provision of fire services and service delivery within a municipality. Fire prevention management plans cannot be isolated from developmental aspirations of a municipality. So some municipalities have adopted bylaws to address nuisances, including fire services, which provide a basis for dealing with properties that are infested with fire-prone material, restricting burning of open fires without a permit. However, there are challenges with these municipal bylaws that include failure of these bylaws to provide adequate legal means for reducing fuel load of properties, particularly in the form of invasive alien vegetation. There's often a conflict between municipal prohibitions on open fires and the need to conduct ecological burns in periods of relatively high risk. It is important to ensure that fire safety and provision are an important part of ensuring an effective fire service. So in terms of our position and response to the bill, SALGA undertook a very quick survey in a sample of municipalities in the various provinces and conducted some interviews to ascertain a position at a local government level on the proposed matters of this amendment bill. However, I would like to request from you, Chair, that should it be possible that SALGA could be able to still go back and consult our mandating governance structures, which, as you are aware, are currently being established, that we could be afforded that opportunity. That even though we have had engagements with municipalities on this very on this bill, we do not feel very confident that it hasn't been taken through the various provincial mandating structures. However, our interpretation of the survey from the sampled municipalities in relation to the bill are as follows. In terms of clause 1, that seeks to amend certain definitions and insert new definitions relating to the additional clauses. According to the data that we collected during the interviews, amendments are supported as they modify and expand the definition list for better understanding. So this clause is supported. Clause 2, which seeks to amend Section 3 of the Act, which deals with the formation of fire protection associations, it is also supported. Clause 3, which amends Section 4 of the Act, which provides for the registration of fire protection associations, also providing that state-owned enterprises, public entities, organs of state, and municipalities should join registered fire protection association, is also supported. Clause 4, which seeks to amend Section 10 of the Act, which provides for communication of fire danger ratings, and also empowering the minister to set conditions for the exemption of landowners when a warning in terms of Section 10(1)(b) of the Act, read with Section 10(2), has been issued that no person may light, use, or maintain a fire in the open air in the region where the fire danger is rated as high, is also supported. Clause 5, which seeks to amend Section 11 of the Act, which provides for the delegation of powers and duties, as well as providing the minister with to delegate powers and duties to the South African Weather Services, is also supported. Clause 6, which amends Section 26 of the Act, which deals with the implementation of Chapter 8 of the Act, which provides for the inclusion of peace officers and traditional leaders to enforce the Act under certain conditions. The response that we got from the sample interviews that we conducted, there is a general welcome of this amendment. However, there is it was expressed that there is a need for provision of this clause. There's a need for support to municipalities in the form of being assisted with human capital, as well as resourcing to be able to enforce this Act effectively. And then in terms of clause 7, which seeks to insert Section 332A in the Act, which provides for appeals to the minister against decisions or actions taken under delegation by delegated officers or entities, and the process to be followed. It is also supported, provided that also there is a consideration for reasonable turnaround times. Section 8, which seeks to change the name of the Act to the National Fire Act 1998, it's supported. Clause 9 deals with the title and commencement of the Act, is also supported. In conclusion, Chair, Having assessed the institutional and governance impact associated with the proposed amendments, SALGA supports the bill on the following basis: in accordance with the survey that we have conducted with a sample of municipalities and also in line with the white paper on fire services. We recommend that the bill be supported with the following recommendations. Lastly, that the Ministry of Environment, Forestry and Fisheries introduce measures and mechanisms to support municipalities on awareness, prevention, mitigation, and management of veld and forest fires. That the Portfolio Committee on Environment, Forestry and Fisheries notes that this is a preliminary submission by SALGA that still needs to be taken through our mandating leadership structures that are currently being established. Thank you so much, Chair.
Thank you so much, Dora, for the presentation. And yes, we'll agree that you'll have to get the mandate from the political structure once the structures are fully constituted. But we sincerely appreciate that you've been holding the fort in the absence of the political leadership. So the life is continuing in SALGA. We appreciate this. Colleagues, is there anyone who wants to interact with Dora's presentation? I see Honorable Paulson's hand and the microphone is on already. Honorable Phillips will follow. Yeah, in that order. And then Honorable Bryant will follow after Honorable Phillips. Over to you, Honorable Paulson.
Thank you, Chairperson. Chairperson, look, I like the idea. It all looks good on paper, but then again, in reality, it's something very different. And we've seen this in eThekwini with the UPL fire, where there was a slow response, number one. Number two, and when they responded, they didn't have the correct equipment. That fire was supposed to be extinguished with foam, and instead they used water, and then that caused further problems to the environment. So the incapacity of our fire response systems and processes has created further environmental disasters. Whereas if that place just went up in smoke and no one did anything about it, it wouldn't have seeped into, less chance of it seeping into the oil, into the soil, and then making its way into the river and destroying so many lives and livelihoods. So we just have to also make sure that there's a way that these facilities have the correct equipment to actually deal with any disaster that they have to respond to, because that is the real challenge here. We have beautiful policies on paper, but in reality, it does nothing to avoid catastrophe. Thank you very much, Chair.
Thank you so much, Honorable Paulson. Honorable Phillips, over to you.
Thank you so much, Chair. Thank you very much for the presentation. I'd actually like to actually expand on what my colleague, Honourable Paulson, has said. And I'm extremely concerned about the fact that SALGA doesn't seem to have any way of enforcing the municipalities, or they don't enforce the fact that the municipalities are actually in contravention of many of these acts and regulations. I mean, just for instance, from the 1st of May to the 15th of November in 2021, 738,000 hectares, or a little bit over that, was lost in the Northwest Province alone, with an estimated value of 4.5 billion rand. So again, we have regulations, we have acts, they are there, some of them are funded, but the money is not being used, or looks like it's not being used for what it's supposed to be used for. Regulations are not being enforced, like the one to force a reduction in fuel availability for fires. So I think that maybe what we should look to is actually to find ways of holding municipalities more to account for abiding by the different regulations and acts. And once we do that, then we can actually look at all the nice to haves. But at the moment, we have all these nice to haves, and the municipalities just don't abide by them. It's very concerning because fires don't discriminate against the environment, they don't discriminate against people, and they don't discriminate against animals. We just lose everything to fires. And it's something that I have become very, very passionate about, that we should and we can be implementing mitigating factors to prevent this terrible devastation that is caused by fires. Thank you so much, Chair.
Thank you so much, Honorable Phillips. Can I hand over to Honorable Bryant, then we'll be followed by Honorable Gancho.
Thank you very much, Chairperson. Chairperson, I'm going to save some of my points for when we get to the actual presentation on the amendments, but I think the work that SALGA has undertaken in order to obtain this comment must be commended. I think it is quite extensive in terms of the feedback that's been provided. You can see that they have consulted with all the relevant municipalities and in the various provinces. But I think one of the central themes that keeps coming through is funding and resource concerns. We do have some municipalities, particularly the metros, that are very well resourced. If we look at the firefighting that's taken place, for instance, in the city of Cape Town, and also in the Overstrand recently with those massive fires that have taken place over the past 2 years, we see brand new fire engines and coordination with volunteer fire services and all those sorts of things. But there are other parts of the country, and particularly some of the rural areas, rural municipalities, where they just simply don't have access to the same level of resources. So I think the concerns that are raised via SALGA are very well founded, in as much as the expectations placed on a large metropolitan municipality that has access to additional resources that they've perhaps built up over a long period of time can't be placed on a small rural municipality or district municipality where you might not have the same access to those resources. And I think this is certainly something that needs to be taken into consideration and made provision for and acted upon going forward. Thank you, Chair.
Thank you so much, Honorable Bryant. Honorable Gancho.
Thank you, Chairperson, and also I would like to thank SALGA for their presentation. Chair, I am coming from an area called Kokama, specifically Tsitsikamma, where we have a lot of plantation, and we are also affected by veld fires, as Honorable Bryant has mentioned, that in the past 2 years, the Western Cape part was affected by veld fires, but the resources in terms of fire trucks, we don't have them, and we will see that the trucks that are used are not the off-road fire trucks where they can be able to go in the veld when there's fire. So I think they need to, when they give these resources, they need to categorize municipalities or the areas especially where there's plantation and also where the area is mostly affected by veld fires, where they really need those off-road fire trucks, because you will see that there's fire trucks, but they are standing on N2. They cannot reach the area where there's a fire. So I just wanted to highlight that, Chairperson. Thank you.
Thank you so much, dear colleague. Then I should think then to join the other colleagues. SALGA, I think we need to commend you for the good work that you've done. Number one, in consulting your constituency, and then also you have validated and critique these proposed amendments. We think we need to appreciate that, and then we'll still then, as and when we move, because what you need to do it's then just for your leadership to then okay what you have said, then you can then resubmit. But I should think there's nothing that is going to change. In fact, now then that they won't say it's not because it's coming from municipalities. It's just for the leadership to have ownership of the comments. But then can I hand over to you to respond to the other issues as raised by the members? Dora?
Thank you so much, Chair. Thank you, and thank you to honourable members for their comments. Definitely well received in the spirit that's been shared. I think I did mention in my slides about the challenge of the capacity of municipalities to deliver on the fire function, on the fire services function. However, I would like to also highlight that SALGA, in partnership with the National Disaster Management Center, have been partnering with other stakeholders, including the private sector. The efforts are starting to bear fruit because there are quite a number of municipalities that have already received the support in the form of the firefighting equipment, the trucks, the fire extinguishers, the PPE, including the training of the volunteers and the fire officers. We realized that we needed to look into bringing in other stakeholders, including the NGOs, to be able to assist, to assist in strengthening the fire services function within municipalities. So I definitely welcome that, and we are also engaging with the National Treasury to look at the issues around the funding of the fire services, including disaster risk management. However, we are also looking at we are engaging municipalities to disclose to us how they are budgeting for this function and how they are spending the budget. Because for us to be able to actively lobby and advocate for additional resources for this function, we need to have a clear conviction and prove that municipalities are indeed budgeting for this function, that the budget has been spent, but however is not adequate. So we are in the process of doing that. It's all part of the municipal support intervention that came, that was informed by the assessment study that we conducted. So, Chair, I can mention, and I had honourable members saying that it seems SALGA is not able to enforce, and I think the colleagues from the Department of Forestry, Fisheries and Environment who are here, who participate with us in the MinTech and in the MiniMec, can attest to the work that SALGA is doing in following up with municipalities that are not fulfilling their function. We identify those areas where they are not complying, and we engage with the officials, including the municipal managers. We have requested the support of the HODs in the various provinces, including the MECs, to be able to assist us in ensuring that municipalities are indeed being fully supported, and where they have been supported and there is still no improvement, we have taken it upon ourselves to engage with those municipalities bilaterally, where we have held meetings with the political leadership, including the administrative leadership, to point out to them that if they are not able to report and to comply, they are not only compromising their own municipality, they are compromising the whole of South Africa. And we have seen some kind of improvement. So I can those are some of the comments that I can make in terms of what SALGA is doing on our side, working very closely with the NDMCs and the PDMCs to literally assist municipalities where possible to improve the function, but where they have resources and they are not performing, to take those measures, literally using the carrot and stick approach to be able to move us forward beyond the rhetoric of lack of access to resources, lack of access to capacity. So I think I can go on, Chair, but thank you so much for these comments. Thank you.
Thank you so much, Dora. It's much appreciated. Once we do this, we're going to again advertise the bills. So maybe that's the time we're in, then that concurrence of the political leadership will come into play. Thank you so much. And nothing but you, once they've ratified this, to send us a formal submission. I hope whoever is the president will do that, to send it to us so that we consider that. But we want to thank you for your time. It's up to you whether you continue to stay to hear the others or whatever. It's up to you. And then I've just been informed by I saw the Secretary of the National House of Traditional and Cohesion Leadership writing that the various senior traditional leaders are here. They are welcome. We have initially tried to call you Inkosika Zingonyam. Unfortunately, at the time, SALGA took your space. We're going to adjourn for lunch for 30 minutes, if everyone agrees with me, so that then we can reconvene and quickly finish up the agenda for the day. We're agreeing, person, not the whole hour, 30 minutes. Are we agreeing? 30 minutes?
Yes, Chair.
Agreed, Chairperson.
I agree.
Yeah, we're gonna reconvene at 1:30. At least today we're doing so well. It's like we're going to finish earlier. Thank you so much, colleagues. 1:30 we're reconvening. Enjoy your lunch now. Your lunch 30 minutes.
Recording stopped.
Chair. You are all back. I think I've made a terrible blunder. Will you forgive me for that earlier? Ne? I allow SALGA to present without us getting the briefing on the National Forest and Veld Fire Amendment Bill. I don't know. I'm on a very fast move today. I don't know what's going on, because ideally we should have first process and finish the briefing on the National Forest Amendment Bill. Remember, the DDG presented, there were questions for clarity. Then we should have concluded on that matter prior to me jumping and allowing SALGA to brief us on the National Forest and Veld Fire Amendment Bill. Can we go back to the National Forests Amendment Bill? I want us to conclude for the purposes of the report. If you recall, this is the bill that also went through it was adopted by the National Assembly, then referred to the NCOP. So the NCOP has since brought the bill back to us. That's the bill we need to finalize. The point that what I need to see on this one, the principle that we asked in relation to the National Environmental Management Laws Amendment Bill, because it's the same. This is a 2016 one, if you check that, and the other one that we dealt with the 2017. So the same principle would apply. Then I had to then put this for a decision whether we are in agreement with what the NCOP has dealt with after the DDG has responded to most of our questions, so that we conclude on that one first before we come to that's why maybe I was so fast when she said the others were supposed to come after lunch. I want to apologize for that on my part. But none of you also saw that. You could have said, hey, Chairperson, no. Are we together, colleagues?
Yes, Chairperson, we're with you 100%.
Yes. What's your take? What do we do with this National Forest Amendment Bill of 2016?
Chairperson, if you're tabling it now, I would propose that we agree to the proposed amendments.
Okay. Seconder? Any seconder?
Chairperson, I will second that.
Thank you so much, Honorable. Seconded. Honorable Phillips. Yes. Now you've got a clear reception. Thank you. You've reached your destination.
Yes, Chair, I have. Yes, Chair, I have heard you.
Okay, thank you. Okay, then we come back to, but it was easier for us to also deal with the SALGA presentation because we've already read the bill. DFFE, can you then proceed on the briefing before I allow the National House to come in?
Thank you very much, Chairperson. Our acting DDG responsible for forestry is also going to take us through the National Veld and Forest Act. But I must indicate that your mistake helped me very much, because when SALGA was taking us through their response to the amendment, it was just amazing, because they agree mostly with everything that is amended into this act. So thank you very much, Chairperson. Can I give then to Phumeza to take us through? Thanks, Chair.
Over to you, DDG.
Thank you, DM, and thank you, Chair. Oh no, where is it there? Okay. Oh, all right. Good afternoon to the Honorable Chair and the Honorable members and the colleagues. This presentation will deal with the National Veld and Forest Fire Amendment Bill, which is a bill we are introducing for the first time to the Portfolio Committee after it was approved by Cabinet for it to come here. So we will look into a number of things as outlined on the slide. I'm not going to waste time and go through that. In terms of the introduction, we would like to brief the Portfolio Committee as the DM has indicated. This act was promulgated in 1998. We have amended it twice in 2001 and in 2005. And now we are doing our third amendment based on the challenges that we have experienced along the implementation of the Act. The Act itself, as it's related to veld and forest fires, its purpose is to prevent and combat veld, forest, and mountain fires throughout the Republic. And it also provides for a variety of institutions, methods, and practices to make sure that there is integrated fire management in line with the Disaster Management Act. In terms of our problem statement, as I've indicated, we've noted that there are some issues that we have experienced during implementation. These relate to interpretation and non-comprehensiveness of some of the terms in the Principal Act. Hence, we are amending some definitions or adding some definitions. And then to also deal with issues of cooperative governance to make sure that we are able to collaborate better with our sister departments and the other institutions to make sure that there is integrated fire management in the country. And then also there was an issue of that the Principal Act did not have an appeals process, and we have put in those provisions as well. Now, in terms of the bill itself, the objectives are to amend and insert certain definitions, provide for facilitation for the formation of the Fire Protection Association by municipalities and traditional councils, compel municipalities and other state organs that own or manage state land to join fire protection associations, and also to amend the title of the Principal Act so that it's no more called the National Veld and Forest Fire Act, but called the National Veld Fire Act. Now we've just looked at three main things in terms of how this bill will try and address some of the strategic priorities by government. One, dealing with transformation. There is now an appeals process that we are introducing against decisions taken by delegated powers and duties, and also with the establishment of fire protection associations, promote the inclusion of women and youth in the decision making. And then secondly, we're looking at issues of job creation through this process. The formation or the facilitation and formation of fire protection associations could give rise to job creation. And also there's job opportunities through the expanded public works program through the Working on Fire. And then thirdly, as we know that fires see no bounds, they can affect everything. We're looking at issues of food security. So if we increase compliance and enforcement, then it assists us in terms of prevention and mitigation of the risk of fires to protect food and improve our food security in the country. Now, in terms of the amendments themselves, We would like to amend Section 2 of the Act, which deals mainly with which will deal with the definitions. So what we want to have here is that there's currently no clear definition of a communal land in the Principal Act, and what we would want to do is to insert or propose a definition, and that definition would read in the second last column from the left. It will read as the communal land would mean that it's the land as defined in the Communal Land Rights Act. And what we've tried to do is we've aligned with the existing and relevant legislation. And then the next definition is the fire in the open air. In this amendment, we would like to propose a definition that would mean that a fire in the open air would be any fire, not within a building or structure, but does not include a fire in an area specifically designed for such a fire and maintained by the owner. So this will also assist us in terms of having clear definitions for better enforcement and alignment also with other legislation. The third amendment that we would like to have is in terms of definitions is to have a definition of a municipality aligned to the Local Government Municipal Systems Act of 2000, so that there is alignment in that matter, so that everyone who reads in our bill and in that act, they have the same understanding. The next proposal in terms of the definition, we did not have a definition of what a public entity is. So what we are proposing is that we define it as it is defined in the Public Finance Management Act, so that it's easy for issues related to enforcement and compliance. Then the next definition is the one related to the Act, where we are saying that we would like to insert the definition of the Act, which would mean the National Veld Fire Act, as we are also proposing that the Veld Fire, the Act's name be changed to be the National Veld Fire Act. On the next slide, we are dealing with the definition for the traditional council, and we want to align with the definition that is already there in the Traditional Leadership and Governance Framework Act of 2003, so that there is that alignment. And also we want to define the Traditional Leadership and Governance Framework Act, and we align with that act as well to make sure that there is alignment, especially when it comes to issues of enforcement, there is no ambiguity. And then we have a definition of veld fire, where the gap is currently that the Principal Act is very narrow in terms of defining what a veld fire is, and it does not cover all the different vegetation. So what we are proposing here is that a veld fire would mean any vegetation, a veld fire would mean any vegetation fire that occurs outside a city, town, its adjoining industrial or residential area. This will then make sure that there is inclusion of all vegetation types and all the cultivated lands, even in the other biomes. Then we move to the chapter that deals with fire protection associations. In this amendment, we have picked up that there is no provision for municipalities and traditional councils to facilitate the formation of fire protection associations in the areas of their jurisdiction. The proposal is that this clause would read, it will be a clause 3A that will say that the municipality consent, and in the case of a communal land, a traditional council established in that area in terms of Section 3 of the Traditional Leadership and Governance Framework Act, if any, may facilitate the formation of a fire protection association process as contemplated in subsection 3, if the minister is of the opinion that a fire protection association is required. This will then provide for the roles and responsibilities for the municipalities and the traditional councils in assisting or in ensuring that there is a continuation in terms of integrated fire management in the country. Then the next slide also deals with issues related to fire protection associations, specifically the registration part of it. In this one, what we are proposing is that the clause 8 would read, the sub area 8 would read: the owner in respect of the state land, a state-owned enterprise, a public entity, or an organ of state must, within a year of the commencement of the National Veld and Forest Fire Amendment Act 2021, join a registered fire protection association in the area which the land is situated. This will assist us in terms of strengthening the enforcement measures. The next slide deals with the amendments relating to the communication of fire danger rating, where there is a proposal on 2A, where we are saying that when a minister has published a warning in terms of subsection 1B, no person may light or use or maintain a fire in an open air in the region where the fire danger is high or extreme, unless the minister, on good cause shown, exempts in writing a landowner or group of landowners from the said warning, subject to any conditions that the minister may impose. And then part B will say the minister must before granting any exemption, consult the Fire Protection Association of the area, if any, and the chief fire officer. So what this will assist in is that if there are some conservation agencies, as an example, that would require having fires banned in extreme or high risk days for research purposes or whatever the case may be, then they could be exempted if they can show good cause. So the minister can be able to exempt them to do that during that time. The next amendment deals with the delegation of powers and duties. What we are trying to do here is to just align the wording so that it refers to the correct institution. The principal act was referring to the South African Weather Bureau, and we know that now that the Bureau has changed, it's now the South African Weather Service. So that is the amendment that we are proposing. And secondly, that clause also referred to the Department of Environmental Affairs and Tourism. So what we are proposing is that it refers to the department that is responsible for administration of the said act. So the amendment would read as follows. The South African Weather Service, established in terms of the South African Weather Service Act of 2001, if the Director General of the department responsible for the administration of the said act agrees. Then the next proposal relates to the implementation of the act, where we are saying that the principal act did not provide for traditional leadership to enforce the act. So what we are proposing here is that section 26 of the act would then read in terms of 2A, that a forest officer a police officer, a peace officer, a traditional leader, as defined in Section 1 of the Traditional Leadership and Governance Framework Act.
I think it is quite intricate that it exists.
Sorry, apologies. Somebody is interjecting you. I was trying to get who's that culprit. Yeah, but proceed.
Thank you, Chair. Okay, so in this amendment, what we are trying to do is to insert the information on the traditional leaders. So it will read, 2A would read, a forest officer, a police officer, a peace officer, a traditional leader as defined in Section 1 of the Traditional Leadership and Governance Framework Act, and an officer appointed in terms of Section 546 of the Fire Brigade Services Act have the power to enforce the Act, provided they have been trained to be competent in an accredited institution to exercise powers to enter, search, arrest, and seize in terms of this Act. Then Part B would read a reference to a fire protection officer in terms of Section 27, 28, and 29 includes the officers and the traditional leader referred to in paragraph A. And then Part 3 would read a fire protection officer and any officer or traditional leader contemplated in subsection 2A exercising powers under this Act must carry with him or her and produce on request prescribed proof of his or her identity. So this amendment will assist us in terms of enforcement of the offenses and penalties. But what we also try and do as the Act say, that we make sure that there is training that is provided. So as a department, we then, prior to appointing the traditional leaders or as peace officers, we then make sure that they go through training in an accredited institution and make sure that they at least understand what is it that is required from them. Then the next amendment, as I indicated at the beginning of the presentation, that the Principal Act did not make any provision for appeals. So this section, which would then be 32A, would deal with the appeals process and will then comply with the Constitution. So 32A1 would read, any affected person may appeal to the minister against the decision or action taken by any person or entity acting under the power delegated in terms of this Act. And then 2 will read, an appeal under subsection 1 must be noted and shall be dealt with in a manner and in accordance with the procedure prescribed by the minister in the regulations. And then the third part would read, the minister shall consider any matter submitted to him or her on appeal after giving every person with an interest in the matter an opportunity to state his or her case. Then, Chair, the last amendment is the amendment of the short title of the Act to be in line with the definition of Veld fire, and the proposal is that then the Act will be called the National Veld Fire Act. I'm used to the old definition. Now, what we have done, we've done some consultations, especially with the stakeholders that are affected. These would range from the different government departments, SANRAL, ESCOM, the forestry industry itself, the tourism institutions, the weather services, the National Forest Advisory Council, the Transformation Charter Council. We've consulted with the universities and academic institutions, the National House of Traditional Leaders, and some of the research institutions. Then in conclusion, Chair and honorable members, we we are saying that this amendment bill, during its review, we have tried to align it to the Constitution and other relevant legislation to ensure effective enforcement. We further enforce that the state must actively participate in the different aspects of integrated fire management so that we are able to lead by example. And we've set aside some resources as a department to enforce the bill. And we will also rely that we will collaborate with the other government institutions for enforcement. And when we looked at the taking of the bill, we looked at the Schedule 4. So right now we are saying that it's within the procedure set out in Section 75 of the Constitution. Thank you very much, Chairperson.
Thank you, DDG. Can we then get the presentation by the National House of Traditional Leader, or should I start with the National Disaster Management Center? Yeah, I initially called the National Disaster Management Center. Okay, it's like, no, let's start with the National House. I see Jose Siatulo, you are ready to present the National House of Traditional and Khoisan Leadership. I've been given a delegation list. Yes. Welcome, Jose.
Greetings, Chair. Yeah,
okay. I think you introduce your delegation as well.
Yes.
Okay.
Irrigate Nakwe for Medisa, Modula Stilo, Memo Tambi, the whole portfolio committee. I'm here on behalf of the newly elected chairperson, Mem Shauli, the first female, leader within the institution. So indeed, we are transforming. We are very happy, and we hope you will also provide the necessary support. And obviously, the congratulations, we will confer them to her. I'm not here by myself.
We've already done that.
Yeah, no, not just in paper. The voice is a powerful thing. Yeah, Kenali, the Khosi Dumedi in the line. Kenali Khosi Hasiboni, they're from Northwest. We are also with the CEO, Nkosi Nobongo is on the line. We can just start with our presentation. Nkosi Nobongo is the chairperson of the portfolio committee, the justice one she's leading. She will be doing the presentation on behalf of the House. However, I will just be providing an overview of what we think with regards to this bill. Well, firstly, we would just like to, give appreciation because for the first time we see a bill that is really focusing on the ruralitarians, as we are called. It's able to zoom into our issues, specifically with regards to the Veld fires. For the most part, we are left to fend for ourselves when it comes to the Veld fires. And when you look at how we are structured as rural people, especially for the purposes of survival, we are mostly reliant on our animals, which graze in our fields across the country. So we find ourselves in a very destitute and worrying position when winter begins, because we are going to be facing the same problem, because the grass is dry, and then people are going to be start burning the grass. But we have been calling, to say government must look into enforcing certain laws that will ensure that people who burn the fields are punished. So when there's a bill like this, at least it will deal with deterrence. People will not just willingly go and burn fires as they have been doing all along. So we are very happy to have this, because it's not just the grazing issue. As rural people, we rely on traditional healers whenever we have problems. So if people burn the fields, everything, the whole vegetation, you go to a traditional healer and then you find that there is no medication because everything has been burnt by the fire. So it's not just the animals, it's even our livelihoods, our spiritual issues. We cannot go and pray there now because everything is burnt. I was just, opening the floor for Nkosi Ngonyama to come in with your permission, Chair. Nkosi Ngonyama, are you there?
I saw her. She was here before.
Yeah, she was here.
Unless she has connection problems.
Yes, unless let's just check.
Trying to check her as well this side. Maybe Mr. Stolle, can you try to call her? She's here. She's here.
She's here. Okay.
Can you unmute your phone? She must just unmute. She's still on mute.
Okay.
Thank you, Honorable Chair of the committee.
We need to
must I show my face?
Yes. We don't want to talk to robots here.
I'm sweating.
Good to see you. Hey.
Good afternoon, Honorable Chairperson of the committee. Where are my notes? Good afternoon, honorable members of the committee, who are members of parliament, the honorable members of the house, the guests, the ministers and the deputy ministers that are part of this program. I greet to all. I thank you for allowing us to be part of this program. I was juggling between 2 minutes. I'm just coming out of another such a meeting, but we are done. I appreciate that we are given this opportunity to present as the National House. It is worth mentioning, Honorable Chair, that this amendment comes at a time when the entire world is faced with the challenges of climate change. With climate change, we are experiencing things that we hardly experienced when we were growing up. The fires that have just come out of nowhere. We have seen that in Cape Town. One member, as I was listening earlier on, he mentioned the fires that have surrounded Cape Town and destroyed a lot of fire of infrastructure around there. We are experiencing the same challenges even in our rural areas. It is so dry to an extent that one match destroys not only the fields, but also the livestock that many of us are dependent on. So we have received the bill, Chairperson, excuse me, and we have made comments. I would like to go through the comments that have been submitted by the National House of Traditional Leaders. If I'm allowed, Chair, I'm subject to your guidance on this matter. I would like to omit the introduction as well as what our structure is, and then zoom straight to clause 2, which talks on the purpose of the bill. Thank you, Chair. Thank you. I'll just the clause 2 of the bill. Normally, when we look at these bills, we go line by line. So when we respond, then we take out those that we believe that they are very important to be responded on. So we would omit those we feel that they are not a problem or they don't require our response.
I will just zoom to the purpose of the bill. The bill contributes to ensuring that there is a sustainable rural development in the country, as rural development is one of the top agenda items of government. Veld fire destroys many assets and livelihoods of communities every year and threatens food security, and this results in job losses. And it is therefore the responsibility of local government to ensure that there are bylaws in place to ensure that landowners comply with the provisions of the Act. On that note as well, Chair, we were supposed also as traditional authorities. I will emphasize this issue of traditional authority in that in the Constitution, it is written as traditional authority, but in our Act, it talks about traditional councils. We had engaged in a debate to say which word must we use. I strongly feel that the authority, to me, in my interpretation, especially xa ndithetha ngesiXhosa, umuntu uzoyiva bhetele into yokubana i-authority ligunya, i-council liqumrhu. Those are two different things when you interpret them. So I will, in this, for the benefit of this this meeting, I will talk about authority. Our traditional authorities are supposed to be having their own bylaws, but the challenge now, which is not for this committee, bear with us, is that we are still in the process of ensuring that we are properly constituted. So for now, we'll take the ball to the municipalities. It is then, therefore, the responsibility of the municipalities to assist with those bylaws. So the National House of Traditional and Khoisan Leaders appreciates the effort by the Department of Forestry, Fisheries and Environment to introduce the National Veld and Forest Fire Amendment Bill, which seeks to ensure that the Act remains responsive and relevant in the field of combating and preventing veld and forest fires. In traditional communities, there's a way that veld fire is managed, or it was managed, especially in communal land. What we used to do was that fire is having devastating effects, especially on the environment, animals, and people. Veld fires have claimed several lives, as I've indicated earlier, and destroyed so many hectares of forests in the country. Since time immemorial, there were ways of managing fire by traditional communities. They took upon themselves to protect their grazing land through the digging of trenches and cleaning and dry material that could result in fire becoming uncontrollable. Every fire season, traditional communities would go out in numbers with dogs and axes to clear areas in their grazing land to keep away fires. These efforts by communities were initiated by traditional leaders. According to elders in traditional communities, certain places were deliberately banned so that in case of fire break, the fire would not spread to larger areas. Before any grazing area was banned, communities would gather at the traditional leader homestead where traditional beer was brewed and bull slaughtered and rituals performed. I wish to mention under this particular clause, it's not written, but these are my comments, Chair, that because now we have, there are laws that are governing certain species that are in our communities, and the environmental laws that seeks to protect those species, which are known as indigenous species. We need to work together, hand in glove together with the Department of Environmental Affairs in order for us, first, before we embark on that, to identify and know those indigenous species or those rare species so that we don't ban them or destroy them. So in the spirit of intergovernmental relations, then we need to have that kind of a partnership and working environment. This was done to ask ancestors to calm the fire so that it would not get out of control. Before the banning exercise, young men would send to scare off animals. Traditional leaders also discouraged the use of fire in the harvesting of honey. And communities were encouraged to smoke the bees out with cow dung at night instead of starting up small fire that might destroy the veld. In the case of animals, hunters were encouraged to use traps instead of smoking out animals out of their holes. So these were the ways of trying to deal with the issues of starting a fire that would, at the end of the day, become uncontrollable and destroy the entire veld or the forest. Traditional leaders have a task of educating their communities not to throw away pieces of mirrors, bottles, and shiny objects that are reflective and could easily trigger fires if exposed to extreme sunlight. At any homestead, there are places dedicated for the disposal of ashes and burnt coals. I think I've touched on earlier on the issue of climate change. We are experiencing at some point where you have 40 to 45 degrees, and this can easily trigger fire if we've got bottles lying around. So we were taught of those things at some point. Traditional leaders are of the view that they should be involved in anti-fire campaigns by government, which focuses on modern ways of controlling fires. There should be dissemination of information by government to rural communities through education on laws that govern the use of natural resources by communities. Government should also assist by providing firefighting facilities to traditional authorities and dams to be built to assist in diffusing the fires in communities. We spoke at length about this, Chair, especially on the building of dams in rural communities. The emphasis we made was due to the fact that we cannot really rely on municipalities. The villages are very vast. They are scattered far from each other, and on the resources the municipalities are having can, at some point, truth being told, not cover most of the areas in rural communities or under their jurisdiction. Hence, we made a recommendation that the focus should be to build these dams so that they assist the rural communities in the event that there's fire to curb those fires. We know that we cannot be provided at some point with fire engines, all the communities to have each a fire engine equipment. So this is a recommendation we are putting in as far as this act is concerned. Excuse me. The National House of Traditional and Khoisan Leaders' comments and submissions with regard to the national fire are as follows. Going now to clause 1. The Act defines a community as a coherent social group of persons with interest or rights in a particular area of land, which the members have or exercise communally in terms of an agreement, custom, or law. We recommend that traditional community be defined as recognized in terms of Section 3 of the Traditional and Khoisan Leadership Act 2019, which is Act number 3 of 2019. The intention, Chair, here is that let not be a contradiction in as far as the definition of a traditional community on another act vis-a-vis our act. We encourage that each and every sphere of government that intends to talk about traditional community should look into our act in terms of definition, hence the recommendation. It is our further recommendation that the following new definitions be inserted in the bill as follows. Traditional council. The Act talks about traditional council, but I've stated my reasons of saying it's traditional authority, but because now in the Act it's still written as traditional council, I will read it as is. Means a traditional council contemplated in Section 16 and includes a traditional sub-council contemplated in Section 17 of the Traditional and Khoisan Leadership Act 2019. Traditional leadership means a person who has been recognized as a king or queen, principal traditional leader, senior traditional leader, or headman or headwoman in terms of Section 8 of the Traditional and Khoisan Leadership Act 2019 and includes regents, acting traditional leaders, and deputy traditional leaders. Further, note that the Traditional Leadership and Governance Framework Act has been repealed by the Traditional and Khoisan Leadership Act, Act number 12, 2019. So some people might have forgotten, just to refresh their memories. We are no longer using the old act now, so we are using the new act. Hence, now we keep on referring to the TKLA, which is Act number 12, 2019. Clause 2, formation of protection associations. The insertion of Section 3 in brackets 3A makes provision for the municipalities and traditional leaders in communal land to facilitate the formation of fire protection associations. If the minister is of the opinion that a fire protection association is needed, we are in support, traditional leaders support the insertion of this new section where traditional leaders will be allowed to form an association in traditional communities where there are felt fires for the purpose of predicting, preventing, managing, and extinguishing felt fires. Traditional leaders further appreciate the fact that in a traditional community where the minister is of the opinion that a fire protection association should be formed, she will convene a meeting in the area explaining the provisions of the Act and provide support and assistance for the formation of a fire protection association. Traditional leaders should also be assisted with funding from the department when establishing the Fire Protection Association and be allowed to chair the meetings of the association. This chair is due to the fact that if these associations are going to be formed in rural communities, it is worth mentioning, Chair, that there has been a challenge when a particular department having its own act establishes something that seeks to undermine what has been the structure that has been there since time immemorial. It creates clashes. I will mention one, a CPA, which has got to do with the department of Dr. Da. There are conflicts around that. So I'm citing this example just to show that the reason why we are requesting that if this is considered as we pray for its consideration is that such structure or such association should be led by the senior traditional leader, alternatively a person delegated by the senior traditional leader. Clause 6, enforcement. This clause provides for the inclusion of peace officers and traditional leaders to enforce the Act, and further grants peace officers and traditional leaders the power to enter, search, and seize relevant evidentiary material in the enforcement of the Act. We appreciate the inclusion of traditional leaders in the enforcement of the Act and recommend that the department should provide support, capacitate, and explain the provisions of the Act to traditional leaders. Chair, it is also one of the issues that would like to be considered as we are putting our recommendations in as far as this bill is concerned, in that there are things that we intend to do, but as long as we are not trained, it becomes difficult to perform those functions. Like, for instance, if you search a person and you are without a search warrant, it becomes a problem in as far as the law is concerned. Hence, now we recommend that before we embark or we start this particular exercise, if the Act is amended as our input, we request that we be trained first and we be provided with the necessary papers to effect and to make our work easy. On that note, Chair, and in closing, we are hoping that our comments will be considered. This is let me pause. I thank you.
Thank you so much, Nkosikazi Ngonyama, for that thought put. And I think we need to appreciate the fact that you also then alerted the DFFE officials to say for them to continue to refer to the Communal Land Rights Act and the Traditional Leadership Act, to the Traditional Leadership and Governance Framework Act that are already obsolete and repealed. Then it makes their presentation legally weak to refer to this. I shall think they are going to rework their presentation and then quote the new amendment X to that effect. Having said that, so that we don't cloud a lot of things, then let me allow the colleagues to ask questions on the presentation by the department and the National House of Traditional and Khoisan Leadership. Then we'll then deal with the other remaining presentation. Can I get a show of hands? Colleagues who want to interact with the two presentation. Honorable Bryant, over to you, colleague.
Thanks very much, Chip. Thanks, Chairperson.
Thank you.
Chairperson, I mentioned some of this earlier when we were speaking after the SALGA presentation, but just to expand in terms of the formal presentation on the amendments and just some questions there, in terms of the concerns that have been raised around resourcing. It really is something that we need to know that has been considered and that it is going to be factored in going forward, because the last thing we want is to place or to raise the expectations in terms of what certain municipalities are going to be able to provide, and then to find at a later stage that they are unable to provide those and are in a more difficult position than they were before. As we mentioned earlier as well, there are certain municipalities that augment their own firefighting capabilities by using volunteer fire services. And I'd like to know whether or not the amendments that have been proposed are going to make it difficult for those volunteer fire services to be part of the process. I did see in terms of I think it's clause 3, section 4, where the amendments on section 4, where they're referring to the fire protection organizations and the registration fire protection organizations. My question would be, what constitutes a fire protection organization? What would the criteria be? And what are the sort of minimum requirements to be involved? I know there are people, for instance, who volunteer to assist when there are major fire incidents, but they might not have the same high level of training as some of the firefighters who work in the municipality. So I'm just interested to know how that is going to be carried out and what those specific requirements are. And then in terms of the actual enforcement that is going to be expected from the traditional leaders, I think there were some very important points raised by the traditional leaders' representatives in terms of whether or not they're going to be empowered to effectively enforce those requirements that are going to be placed on them. And I'd just like some comment in terms of those concerns and how that will be carried out effectively to make sure that those traditional leaders are empowered and properly trained in order to carry out that enforcement going forward. Thank you, Chairperson. Oh, sorry, just one other question quickly. The new amendments, in terms of the jurisdiction around the regular burns and the cutting of fire breaks, I know that has been a shared responsibility somewhat, and whether or not that is going to be now placed in the hands of municipalities entirely, or if there will still be a shared responsibility between the different organs of state. Thank you.
Thank you so much, honorable colleagues. Can we then go to Honorable Phillips?
Thank you so much, Chair, and I'd like to thank the presenters very much for the presentation. I have a few concerns. The one is that the working on fire that is going to create the jobs, it does seem to be hamstrung by the fact that it's run for a by-profit company instead of being a non-profit company. So I'd like to know if how that is going to be addressed, because I know in the Northwest, our Fire Protection Association is actually hamstrung by having to rely on the working on fire people who are run by the for-profit company. And then I'd like to reiterate my colleague when she said that not all the fire vehicles are suitable for going out into the terrain where the fires often occur. And I think that really needs to be considered. And then the availability of aircraft to putting out fires cannot be overestimated. I know there was recently a fire in the Pringle Bay area, and because the aircraft could be dispatched really early, they were able to get the fire under control very quickly. And the thanks go to the mayor of that particular municipality for taking it on herself to actually dispatch the firefighting aircraft. So I think the ability to get in to far-flung and difficult places becomes very, very important. You know, that is where a lot of our cattle are grazing, it's where a lot of our people live, and it's also where a lot of our vegetation is that burns. So thank you very much.
Thank you so much, Honorable Phillips. Welcome, Honorable Singh. Got your apology earlier, and I'm glad that we started with you during the second batch. Can you proceed?
Yeah, no, thank you very much, Chairperson, and good afternoon to colleagues. I had to fly back from Cape Town, and I got a bit delayed getting back to my office. So I think I missed some of the presentation. So please forgive me if I ask questions that answers were given. But just to get an understanding, this act applies in, as I said, outside urban and city areas. Am I correct in that?
Yes, you are correct.
Okay. All right, okay. Now, Chair, it's nice to have legislation, and I really appreciate the presentation by Kosi. It was really well prepared, and, you know, I think puts me personally to shame in terms of preparing for this kind of legislation. So well done. I look forward to hearing the other departments as well. But as far as the department is concerned, you know, when you have legislation and amendments, funds always follow functions. Now, there are lots of responsibilities that are being proposed at different levels of government and with different agencies here. Where are they going to get the funds from to carry out these functions? Is National going to provide? Have they, in looking at legislation, and you know, when it goes to cabinet, one of the questions is, you know, what's the funding implications of this? So I'd just like to know if that exercise has been done. And in terms of, you know, liaising with other departments, you spoke about IGR and things like that. You spoke about public EPWP. Now, you know, you get in rural areas, you find there's no electricity. People have to use fire even to keep warm. And you know, even those that are herding cattle, etc., light fires. I mean, it goes beyond just saying how we should prevent fires and things like that. It's a socioeconomic issue that I think that we have to deal with. And, you know, we just cannot impose legislation on people that may not have the means to do anything else. But, you know, and unfortunately, these fires do start off. So to what extent is EPWP working in these areas to clear fire breaks, etc.? There are informal settlements sometimes even in the rural areas. And we know, you know, you get huge fires there, paraffin, they use paraffin stoves, etc. So what capacity has government got to assist these communities? We cannot just pass it on to these communities. And I think Kosi asked a very valid question on the type of vegetation. What are the more flammable vegetation or plantations? Do we have a database of that, and where do they exist? Because in many areas you get EPWP coming in and clearing up, like, you know, wetlands, etc., etc. Now, here are the areas where this type of vegetation can be cleared by government to assist communities. And I just like to also know is, you know, in terms of the department, you know, you talk about conviction, you talk about the minister trying to grant permits, etc. Have there been anybody that has been convicted for any part of the act that they may not have complied with over the past 5-10 years, and how do we do that? What kind of convictions were forthcoming in this regard? Because I don't know if we are putting an undue burden on communities that may not be able to, in themselves, manage these things. Because traditional leadership, I think even you'll know better than I do about the acts and the powers of traditional leaders. Rural municipalities don't even have a rates base at all. It's only the huge farmers that are in forestry, etc., that are capable of having, fire equipment. So I'm just asking the general questions so that we can get some response from the department. Thank you.
Thank you so much, Honorable Singh. Honorable Phillips, over to you. Honorable Phillips. Oh,
Chair, I think that may be an old hand, Chair.
Will be an old hand. Okay. Let's proceed then under the circumstances. Can the department respond to the issues that relates to them? Then I'll also allow the National House of Traditional and Cohesion Leadership to comment on some of the things as raised by members. Department.
Thank you, Honorable Chair, and members for the questions that have been raised. In terms of the resourcing, yes, I agree that there is a need to look at the resources that we have versus the resources of the institutions that we would like to make sure that they collaborate with us. So, for instance, I think a clause, the amendment on section 26 does give some idea that, for instance, when we talk about inclusion of traditional authority in terms of assisting with enforcement of the Act, we would then provide the training and we cater for that. We then make sure that we have the funding for them to be trained and all of those things. And we also appreciate the comment that has been made that they would need additional information. So we do have our awareness campaigns that we do, and we will just make sure that they are included in those campaigns to make sure that they get the information that they need, they get to understand what can be done, and the information on the plants, especially the indigenous species that would need to be protected and all of those things. So it is something that the department does, and we can be able to provide that information and collaborate further with the traditional authorities. The other issue that has been raised is what constitutes a fire protection association. In terms of the Act, a fire protection association is an organization that brings together the different landowners where they collaborate in terms of how would they want to manage fires in their areas of jurisdiction. Because the Act, the Principal Act, gives or places the responsibility of a particular landowner to be responsible for the fires within their areas. So this group of people would then come together, obviously with the assistance of the department and the assistance as well from the municipalities and the NDMC, in terms of making sure that there is a fire protection officer, which could be a person that is already employed by the municipality, So there are responsibilities there of making sure that there is training that happens for the fire protection associations, and this is outlined in the Principal Act in chapter 2, where in section 4 and 5 that deals with the registration and the duties of these fire protection associations. So what then the department does is we would then produce what we call a Veld fire risk map, which then outlines which areas are of high risk and where these fire protection associations can be aware of. And then the other thing that we do is to make sure that we have collaborated as well with the MDMC as they are busy amending their different acts. We've had some discussions with them through the master plan, the forestry master plan, where fires have been identified as a major issue, and the MDMC is currently amending their act, and there's a section there also that deals with training. I think it's section 46 that deals with training, where we will then be able to collaborate with them. And then in terms of enforcement, I've dealt with the issue of how we want to empower the traditional authorities, and we plan to do that through getting the institutions, accredited institutions to support the training of the traditional authorities and all the other people that we then appoint as peace officers. In terms of the then the other thing, in terms of providing support to the FPAs, we are now in a process of developing a strategy where we are looking at how do we then support the FPAs in providing them with assistance, whether it's equipment, whether it's training, and in recognition that there's different levels of FPAs in the different country. Some of them are well resourced, mainly because either they have metros that are part of them, or some have the forestry industry, which is a part of those FPAs, and those would be well resourced. But then through the work that we do, we will then, through that strategy, make sure that there is that assistance. I don't know what I have not responded to, and I don't know if maybe Mr. Madula would want to add on what I might have missed on the issues related to, I think, enforcement and also the capacity of the FPAs that we have.
Before Mr. Madula responds, acting DDG, the guys from legal and the regulatory team and compliance branch, can you admit that somebody has been sleeping on the job that makes you to draft and refer to legislations that have already been repealed? It brings bad much to the quality of the work. Because you see, Inko Singonyama had to even refer that to you. Am I understanding that only a senior legal admin officer there and the director for legal services should be privy to what amendments are happening, especially legislations that has got impact to you? So for you to come and refer to an old legislation in your documents, I think it's uncalled for. I would like to hear your comment on that as well. Or is Mr. Madula is the one that's going to respond to that?
I think Chair Linda is going to assist.
Unmute. We want to hear what you are saying, Linda.
Oh, sorry, sorry, team. Sorry, Chair. I think the reason I do not. It is unacceptable, I must say. But what happened? You must. These bills are old bills, and it was just not revived. It was withdrew and then processed again. And I think.
Linda.
Yes.
That's no excuse on a serious note. If it was the other one, the amendment one, I will agree. This is the one that somebody did the presentation.
Okay.
No. It means that you are bringing us old things that are old, that are not in line with what is currently happening. And then you'll come back and again later, because if somebody didn't pick it up, it was going to go as it is. And you reference to a wrong legislation altogether. The point that we're trying to raise here, people must exercise due diligence. And when people submit stuff to us as Parliament, they mustn't just do it for malicious compliance. We're urging you to be thorough. So that excuse to say it's an old thing, it means then, when was this bill? I'll ask a question now to say, you are bringing it to us for the first time. It has went through cabinet processes, but you have got the responsibility. The time you were presenting, you were making this presentation, somebody, if we were robust and robust with our work, somebody should have picked up, especially the legal guys, because there's a team there. You know what I'm trying to say?
Yes.
There's a team there. It's quite embarrassing. In fact, if I were the relevant official, I should have been very much embarrassed to get it from Inkosi Kasi Wonyama saying that this is what is happening. She picked it up before we could even raise it.
I agree, Chair. And I apologize for that.
You apologize and muted. We're not supposed to respond to other stuff as well. It was only for that one. Linda?
It was only for this one.
Okay. So we're done with the department and the National House of Traditional and Khoisan Leadership. Then, Giletta, who's next? I'm trying to quickly get my... Who should be next? And we then allow the Department of the National Disaster Management Center. The National Disaster Management Center.
Thank you very much, Chair. Good afternoon to you, Chair, honorable members, the Deputy Minister, and all esteemed guests that are part of this occasion. Thank you for the opportunity accorded to the Department of Cooperative Governance to table an input in respect of this matter. My name is Mapaga Dau. I'm head of the National Disaster Management Center. I have been asked to represent COGTA Minister Dlamini Zuma and our Director General of DCOG, Ms. Avril Williamson, who are committed on other matters today. Chair, as you would be aware, also the Department of Cooperative Governance administers few pieces of legislation that have a bearing on the subject matter for discussion today. And those pieces of legislation include, but are not limited to, the Disaster Management Act, the Fire Brigade Services Act, the Municipal Systems Act, and Municipal Structures Act. We also want to just reaffirm the point that has been made by Ngoskas Ngonyama that there is overall consensus, Chair and honorable members, that climate change is increasing the frequency and severity of droughts, wildland fires, and extreme weather events in South Africa. And in densely settled communal areas, poverty and land degradation resulting from a number of factors such as unsustainable use of fire on various biomes are exacerbating climate impacts. And this leaves many rural communities vulnerable to these hazards. And the Disaster Management Act then becomes an overall piece of legislation that has to ensure that all sectors perform their sectorial responsibilities to manage various hazards that they experience. And we are so delighted that the Department of Forestry, Fisheries and Environment has taken this important discourse. This situation, Honorable Chair and members, calls for a judicious developmental approaches by all role players within the framework of the municipal planning processes. To this end, municipal fire services must develop appropriate strategies to manage felt fire risks in view of the challenges brought about by climate change and climate variability. Mine is not a complete speech in respect of what we have prepared, Chair. We have a presentation, I think about 20 substantive slides that I'm going to request my colleague, Ms. Anne Brewer, to table to the committee for consideration. And I also want to endorse the point that Nodada has also made to the effect that we have been working together as the National Disaster Management Center and the Department of Forestry, Fisheries and Environment in respect of this matter. So I want to therefore hand over to my colleague, Ms. Anne Brewer, to table our presentation on behalf of our Minister. Thank you very much.
Thank you, Dr. Del. Can we then allow Ms. Brewer to present as you have directed?
Thank you very much, Chairperson. Good afternoon. Good to see you again, and honourable members. I noted that the screen sharing is disabled on my side. I just want to check if the Secretariat can present the presentation or share the screen, or allow me to share the screen, please.
You can fly to Annie now.
Thank you.
Pleasure.
Okay. I believe you can see the screen or the slides.
Yes, we can, Annie, thanks.
Thank you. Okay, then thank you again. Thank you very much for the opportunity. As the head of the center already introduced myself, Anne Brewer, I'm from the National Disaster Management Center, and good afternoon to all the honourable members. So in terms of our presentation outline, we basically wanted to just give you an overview of the risk in South Africa, and also just deal with a few of the interfaces of legislation that is administered by our department that has a bearing on the bill. That is the Disaster Management Act, the Fire Brigade Services Interface, and also then just look into the integrated fire management and reporting and enforcement issues and other aspects that may need to be considered in processing the bill. So basically, the presentation clarifies the role of the National Disaster Management Center, but also the provincial disaster management centers and municipal disaster management centers, which have a responsibility in terms of awareness, prevention, mitigation, and management, including inspections and enforcement of natural and unnatural fires within the context of the bill. And that is what we were asked to present to the Portfolio Committee this afternoon. So in this regard, we will also provide an overview on the commitment of government through the white paper on fire services to reposition fire services from the mainly responsive-oriented approach towards a fire risk reduction-based approach. So we have the head of the center already mentioned that the white paper that we have published. So, and secondly, also the need to strengthen collaboration with other partners and stakeholders, including those in the private sector involved in the provision of fire services. And that will also then include the FPAs. This slide basically alludes to the risks that we face in South Africa, and I think enough has been said about climate change and the impact it has on the risks. And as you know, we have to deal with hazards, weather hazards, including drought, cyclones, and severe storms that can trigger widespread hardship and devastation. The climate change impact has been seen in our country in terms of water availability and the impact on agriculture and ecosystems. And then, of course, we all know the impact of COVID-19 and other things that are emerging in terms of disaster risks. So if we look at the legislative authority in terms of fire services, I think it is important that we quickly just remind ourselves about the powers of legislation in the country, the legislative powers, and then note that the legislative authority of the national sphere of government is vested in Parliament, whereas the legislative authority of provincial sphere is vested in the provincial legislatures, and that the authority in the local sphere of government is vested in municipal councils. And therefore, it's important also to note that in terms of Schedule 4 and of the Constitution, and also Schedule 5, Part B of those schedules, is assigned to national or provincial legislation, and that in terms of the Constitution, firefighting services is a local government matter and a functional area of concurrent national and provincial legislative competence. We must also take note that in terms of Section 156 of the Constitution, it provides the municipality may make and administer bylaws for the effective administration of the matters which it has the right to administer. So therefore, the municipalities may make bylaws with regards to fires in their area of jurisdiction. So the role of the National Disaster Management Center and of local government in awareness, prevention, mitigation, and management of natural and unnatural fires within the context of the bill that we are dealing with is broadly set out in the legislation that we have already mentioned, and that is the Disaster Management Act, specifically chapters 3, 4, and 5, and the chapters that deal with municipal disaster management. Then the Fire Brigade Services Act, we have sections 2 and 15, that is basically the, dealing with the Fire Brigade Board and regulations at the national level. But then we also have the other sections that is basically dealt with at provincial and municipal level. And then the Local Government Municipal Systems Act, which talks about assignments and also specifically integrated planning in chapter 5, the IDPs and all the things that is required in terms of integrated planning, including the disaster management plan. And then also the Local Government Municipal Structures Act, which talks to the functions at municipal and district level. So if we quickly look at the Disaster Management Act, it is important that we just highlight a few areas. The one is the responsibility of disaster management centers in terms of prevention and mitigation. to give guidance to organs of state, the private sector, NGOs, communities, and individuals in the municipal area to assess and prevent or reduce the risk of disasters. And these obviously include those caused by natural and unnatural fires, and things that must be done in terms of determining levels of risk, assessing the vulnerability of communities, and I think the Veld fire risk maps was mentioned earlier. So these are the important things that must be developed in that space. In terms of the sections 52 and 53, there is also a responsibility for all organs of state across the three spheres of government to develop disaster management plans. And each municipal organ of state must also conduct a risk assessment for the area, identify and map risks, and prepare an actual disaster management plan that sets out all the things required and how they will deal with, with the risks in the area, and where the vulnerable areas are, and what are the contingency strategies and emergency procedures in the event of a disaster. An important thing here is also the measures to finance these strategies. So I think that is something important that we also just need to that I would also like to highlight later in the presentation. Then a disaster management plan must also be developed for the municipal area. So that is a third level of disaster management plan. So the municipality must look at the entire area for which it is responsible, and look at how they deal with disaster risks. And obviously fire risks is a very important factor to consider in terms of developing that plan, and where the fire protection associations will play a very important role. Then there's also an obligation on the municipality to say that when a disastrous event occurs or is threatening to occur in the area of the municipality, the disaster management center of the municipality must determine whether the event should be regarded as a disaster. And if so, they must initiate efforts to assess the magnitude. They must inform the national and the provincial disaster management centers. They must alert disaster management role players, and also initiate the implementation of any contingency plans and emergency procedures that may be applicable. So here, once again, that the planning becomes very important, and taking all the stakeholders on board, and having a contingency plan specifically then for for Veld fires, and clarifying the roles and responsibilities in the area, but then also to do the necessary in terms of alerting the various disaster management centers. I just want to indicate here that maybe for understanding, disaster management centers must be established at the national, provincial, and the district level, district or metro. So usually a local municipality do not have a disaster management center, and they form part of the broader arrangements for the district. Okay, then if we move on to the Fire Brigade Services Act, you will see it's quite an old act, 1987, and that is why we have embarked on a process to come up with a new set of a new piece of legislation. But as it is, a fire brigade service is intended to be employed for preventing the outbreak or spread of a fire, fighting or extinguishing a fire, the protection of life or property against a fire or other threatening danger, the rescue of life or property from a fire or other danger, and some other functions also set out. So it also specifically talks about the jurisdiction, which says it shall apply in the national territory referred to in Section 1 of the Constitution, but a local authority may also establish and maintain a service in accordance with the prescribed requirements. The next slide talks about the authority to make bylaws and regulations, and that will also be very important in terms of dealing with veld fires. And then, the process is set out of what can be done, and the responsibility of the chief fire officer. So it says the chief fire officer may at any reasonable time enter any premises in the area of the controlling authority concerned in order to determine whether the provisions contemplated in the Act are being complied with. So they can also enter these premises, and then they also have certain authority to write notices of non-compliance. One of the objectives of the National Disaster Management Centre is also to oversee the administration and implementation of the fire services legislation and the performance of duties. So the NDMC coordinates several national institutional structures relating to fire services and also disaster management. The NDMC convenes quarterly meetings with its provincial counterparts to ensure effective multi-sphere coordination of fire services. And a number of working groups have also been established to look at sector-specific issues such as fire safety, the rear pathing, and capacity building. In addition, the NDMC provides support to provincial fire services structures through participation in meetings and related activities. There's also a role to play in terms of integrated fire management or integrated veld fire management, which refers to a series of actions that includes fire awareness activities, fire prevention, prescribed burning, resource sharing and coordination, fire detection, fire suppression, fire damage rehabilitation and research at all the spheres of government, and also in order to create a sustainable and well-balanced environment, to reduce unwanted wildfire damage and to promote the beneficial use of fire. So it actually refers to the to the balance of the damaging effects of fires, but also acknowledging the need for good fires that is necessary for a well-balanced environment. So in this slide, there's just explanation of the role of the chief fire officer in terms of the Fire Brigade Services Act, and then also the role of the Fire Protection Officer in terms of the Veld and Forest Fires Act. So I think the only thing that we need to say here, that it is important for the FPA to work closely with the chief fire officer in order to effectively manage veld fire risks in each area. And this means that the chief fire officer remains at the heart of the sustainable management of fire risks, including veld fires within a municipal area of jurisdiction. Because the chief fire officer is actually employed by the municipality, and his or her responsibilities covers the entire area. So there must definitely be close interface, but also understanding of the roles and responsibilities of these two positions, basically. Then when we look at integrated reporting, a municipal fire service must submit a report annually to the municipal council on particular problems that were experienced in dealing with major fires. Apologies. And generally in implementing the Fire Brigade Services Act. And then also including the way in which problems were addressed, and make some recommendations in terms of fire services and the improvement thereof. And also, municipal fire services must, while its report is submitted to the Municipal Council, also submit that report to the National Disaster Management Center in the Department of Cooperative Governance, and also to Forestry in the Department of Forestry, Fisheries and the Environment, as well as the respective provincial departments that are concerned. If we broadly look at enforcement of natural and unnatural fires within the context of national legislation, I think we've talked about awareness that is required in terms of the Disaster Management Act, and also to get all communities and all stakeholders on board. Also in terms of prevention and the role of further education and training colleges in terms of the provision of fire services training and education, and also to explore mechanisms for providing specialist training to the sector. I think some of these issues have also been mentioned in earlier this afternoon. Then in terms of mitigation, the NDMC developed a uniform fire risk assessment framework considering the SAN standards of community protection against fire and other relevant internationally accepted standards. And this is also achieved by promoting standardization of norms and standards through model bylaws, by assessing municipalities through fire safety and prevention capacity assessments. So that is some of the support provided by the National Disaster Management Center. And then in addition, fire services supports community initiatives aimed at reducing fire risks within its area of jurisdiction. So that is more from a municipal point of view. In terms of management, as much as the organs of state is experiencing some challenges with regards to enforcement in relation to fire management, the NDMC has encouraged municipal fire services to train more fire officers to be peace officers. And this will enforce compliance with the municipal bylaws and FBA requirements. So that will assist if training can take place in that regard. And I think specifically also the aspect mentioned in terms of traditional leaders. Then inspections, each fire service is empowered and encouraged to conduct a fire risk assessment to identify all fire hazards and risks in its area of jurisdiction, and then to conduct inspections to ensure that safety standards set out in bylaws are maintained. So this is also a responsibility of the municipality. And each fire service is required to categorize occupancies in terms of or into high, moderate, and low risks after considering life and property risks, and then assign a minimum inspection frequency. The next slide is a little bit small, but I just want to draw your attention to some of the other pieces of legislation that the department administers that has an impact on this the specific bill. And that is firstly the Local Government Municipal Systems Act. And as you know, it talks a lot about cooperative governance and the rights and duties of municipal councils, and gives some general empowerment to municipalities and also assignments. So if we can just look at the recommendations, we propose that we recommend that the principles of cooperative governance should be entrenched in the bill, so that the objectives of the fire protection associations in an area is seamless with the objectives of the fire brigade services and disaster management legislation and also the structures as it relates to the preventing, reducing, mitigating the severity of and promoting emergency preparedness, and also ensuring rapid and effective response to veld fires. Secondly, in terms of the rights and duties of municipal councils, they should be entrenched also in the bill and the deliberations, so that the ability of a municipality to govern the provision of firefighting services as it relates to veld fires that occur in its area is not in conflict or against those regulating the FPAs established in the area by the minister. And this must be done keeping in mind the concept of wall-to-wall municipalities. I think we are all aware that after 2000, the concept of wall-to-wall municipalities came into play, and therefore the distinction between urban and rural areas and what is felt and forest is a little bit murky. So to make that clear distinction. So that is something that really needs to be considered carefully. And then the next recommendation is again around the principles of cooperative governance. And then the last one is for us also a very important consideration in terms of the cost of becoming a member of a fire protection association, and the chief fire officer performing functions in terms of the Act should be considered. There should be consideration on the implications of assigning the similar powers to a fire protection officer than that of a chief fire officer for the same territory. So I think those things should just be clarified in terms of roles and responsibilities and possible conflict, of interest, because there are also funding at play. Then, if we look at Chapter 5 of the Systems Act, it's about the integrated development planning. The principle of integrated development planning should be entrenched in the bill and the discussion, so that the objectives of the fire protection associations in an area is seamless with the objectives of the fire brigade services and disaster management, as it relates to prevention, preparedness, response, and so on, specifically regarding veld fires, and that must also be incorporated in the disaster management plan, which is a core component of the IDP. Then, in terms of delegations, I think that is also an important one that needs to be considered. The powers and duties that the chief fire officer may have in terms of Section 6 of the National Veld and Forest Fires Act, for example, being the CEO of the Fire Protection Association, carry out tasks assigned to him or her by the FPA or executive committee, and also apply to be a fire protection association. So those are things that that might be difficult for a person to navigate, and may place the person in conflict with delegations or obligations he or she may have in terms of the Local Government Municipal Systems Act and the Fire Brigade Services Act, in terms of the official capacity of a chief fire officer, and then also having to fulfill a role as the fire protection officer. So those things needs to be clarified and clearly identified, and perhaps it can be done through agreements and so on, and delegations in terms of the council. Then general duties, tariff policies and so on is also another area of consideration. The interface of fire protection association rules that may affect the community, with bylaws, mechanisms to provide veld fire services to the municipality as an external entity, establishment of municipal service districts where more than one FPA, for instance, exists in a municipality, and also the establishment of multi-jurisdictional municipal service districts should be considered. The membership fees payable to the FPA must be aligned to the fees process of a council to ensure that the fee structure is in place based on democratic principles. So I think, you know, there's not enough clarity at this stage in terms of the fee structures and the funding models, and you know, what will be required of land owners to pay to be a member. And you know, the membership is also compulsory for municipalities and state land owners. So those things are things that needs to be investigated somewhat. So if we then look at the boundaries of municipalities, I think I have mentioned that prior to the operation of the local government legislation in 2000, it was only required to prevent and respond to fires within the established townships, while the vast, mostly rural areas consisting of veld and forests remained unprotected until the National Veld and Forest Fires Act came into being. So that is why there are basically two pieces of legislation dealing with fires in the country. But with the advent of local government in 2000 and the implementation of wall-to-wall municipalities, the fire services and fire protection associations were assigned the same responsibilities in terms of management of veld fires. So that is why we also propose that the bill consider this quite carefully and make sure there's a mechanism to ensure that the assignment of functions is not duplicated. Then I think the next recommendation is also with regards to the you know, how the council must strive within its capacity to achieve objectives, you know, to address the needs of the community and priorities to meet those needs. And that is just, once again, in terms of prevention and preparedness and reducing the risk of veld fires. Then in terms of Section 72 of the Structures Act, which deals with ward committees, once again, we recommend that the ward committees are engaged in the formation of fire protection associations and the rules governing it. And then once again, Chapter 5, especially sections 83 to 89, around about there, the principles of cooperative governance should be entrenched, and to ensure that the division of powers and functions with regards to fire services are recognized. And this also leads to the functions in local municipalities that are often different to the functions assigned to district municipalities. So this must also be considered to ensure that there is a mechanism to ensure that the assignment of functions is not duplicated. So basically, to conclude, the National Disaster Management Center specifically administers Section 2 and 5 of the Fire Brigade Services Act. And through this enabling mechanism, we developed the white paper on fire services, which was approved by Cabinet last year, and that process is underway to finalize the bill and also put it through the necessary parliamentary process. Then we also promote standardization of norms and standards through model bylaws by assessing municipalities through fire safety and prevention capacity assessments. We hold fire safety workshops with national and provincial structures to enhance coordination and to share good practices. And we also monitor and provide oversight on fire services issues in general. And we have developed a career path for personnel in the fire services, considering the importance of multi-level entry for practitioners. And then one of our very important functions is also to engage with other national sector departments and industry stakeholders on fire services and disaster management issues. So with that, we just want to recommend that the portfolio committee notes the presentation and considers the various aspects that we have raised in the deliberations of processing the bill. Thank you very much.
Chairperson. Is the chairperson of the meeting?
Yes, Honorable Bryant, but I'm calling her now.
But I can see she's still in a meeting.
Yeah, she's in the meeting.
So, like, there was an issue with a couple of us who were struggling with the Zooms. So it might be that.
I think so too. Welcome.
Can I make a proposal?
Yes, Honorable Kendra.
Can I make a proposal that Honorable Modise chair the meeting for now, and then as we are waiting for the chairperson?
I don't think Honorable Modise is on the meeting. I was also just looking to check. Oh, there's chairperson.
I ran to the bathroom. My apologies. Sorry about that. It's difficult when you are. I could hear you calling me from the bathroom. Okay. I see the hand of Honorable Phillips. I thought we'll take also the rural development one because the disaster one is done. So that then we couple them together. Or you want to deal with the National Disaster Management Center, then dispose of it, go to the rural development one.
Chairperson Singh,
Yeah.
Perhaps all of them should present, because what I get a sense, is there's a lot of work here, and maybe they need to, after this, meet together and come back to it. But let's hear them out.
Okay. Is the department ready for agriculture, land and rural development?
Thank you, Chairperson. Yes, we are ready.
Introduce yourself together with the team you are traveling with.
Good afternoon, Honorable Chairperson. Good afternoon, Honorable members and colleagues. I am Mike Medisani, the Acting Deputy Director General for Agricultural Production, Health and Food Safety, and including natural resource management. Yes, I'm trying to show my face. Honorable Chairperson. Thank you very much. We have been requested to represent the department in this important discussion. I am with the team, and then also with Dr. Galafeng Kakati. Our contributions, Honorable Chairperson, will not be very lengthy, but we will be considering, or we have been considering our role in terms of disasters and the consequences of Veld fires and issues that are related to destruction of soil and hence agricultural production. So Dr. Kakati will take us through the presentation, and Mayor Chipeta will also assist with the response to the questions as and when necessary. Dr. Kakati, if the chair allows, we could present.
Good afternoon, Honorable Chairperson. Good afternoon, Honorable members. And good afternoon, colleagues. I see I can't get opportunity of putting the presentation. Can the secretary allow me to do that, or do it on my behalf?
I just granted you rights as a.
Okay. Yeah, it seems my gadget can't allow me. Can Dr. Mudisane do it on your side? It seems my gadget can't allow me to do that.
We're hoping that you will be presenting, so I have to then look for it here. If you allow me, Chair, to find it first. Thank you.
Okay. There we go.
Okay, Doc.
Okay.
Doc, can you start with slide number 1? Okay. Oh, no, thanks, Honorable Chairperson, and thanks, Doc. Chairperson, it's good that we present after the Disaster Management Center because our plans are really within the Act, as Anya has alluded earlier. But maybe, can you go to the next slide, Doc? I'll be talking to these 4 points following the request that we need to talk to the awareness, prevention, and mitigation. We're not really given that option of talking to the amendment of the Act, but it was good because Forestry used to be one of our branches. So when they started with the amendment, we are part of it. So we fully really support the amendment they were already made. But based on the presentation, Chairperson, can you go to the next slide? The purpose, as requested, is to talk to the input to the National Veld Fire Act has now been changed as requested by a Portfolio Committee on Environment and Forestry and Fisheries. Next, Chairperson. Maybe before I introduction, the previous slide. Yes, Chairperson and colleagues, as you are aware, Veld are one of the devastating hazards that have soil, social, economic, and environmental impact, especially to the sector. And that's why we consider the responses to be really highly to be put on the higher agenda. The long-term effects of uncontrolled wildfire ranges from reduction of biodiversity through destruction of flora and fauna to soil infertility. And as responsible for food security, definitely will really be affected. Wildfires further lead to the destroyed infrastructure, increased soil erosion, and decreased infiltration, which are detrimental to agricultural production. And hence, measures need to be in place for their prevention, mitigation, and response. But maybe before I talk to this slide, Honorable Chairperson, as mandated by the COCTA or NDMC led by Dr. Tau, we drafted the plans to be dealing with this hazard of wildfires. But within agriculture, there is also an act, Conservation of Agricultural Resources Act, that also look into the response of dealing with the fires, and in addition to the wildfires. So when we drafted the plans within the sector, we considered these three acts to make sure that we deal effectively with them. And SNA has really alluded what sectors need to be looking after to make sure that those plans are effectively done and in a way be implementable to respond to the hazard as per sector. The key points within the guidelines of the framework are the four key result areas that each and every plan that need to be developed need to be governed by it. And then there are three enablers that within those key result areas, those enablers will be able to effect the implementation of those enablers. One of the enablers is awareness, as we are requested to talk to. And within the Department of Agriculture, Land Reform and Rural Development, we have already have structures in place to deal with the prevention, mitigation, and to manage the impact of disaster risk, including the wildfires. And this is really been drafted within the plans that we have. Awareness creation is one of the critical elements of wildfire prevention in the sector, as fire is one of the tools of field management. The farming community are capacitated on how to adhere to the requirements of the fire danger ratings when the fire has to be used for these activities. Next slide, talk to the permits. The permits within the conservation of agricultural resources are issued to the farmers who will use to fire for field management under Conservation of Resources Act, and monitoring is conducted on the issues permits for the fire to only be used when conditions are not conducive for spreading. So within the agricultural sector, the conservation of agriculture allow the farmers to make sure that they monitor the field, and sometimes during the years and seasons they got the be permitted to do some burning in a way of maintaining their resources. Broader awareness campaigns are conducted to educate farmers to prevent and mitigate the fires and also fight them when necessary. These are also done within the Department of Forestry, Fisheries and Environment in the provinces. Next slide. As well as requested to deal with the prevention and mitigation, and this as outlined and broadly on our plans. Prevention and mitigation are done through communication of awareness of warnings and creation of fire breaks, among others activities. As we are working closely with the two COCTA and DFFE, as well as SOurce, we make sure that these warnings, when there are issues, we make sure that there are strategies that are accompanied and allow the farmers to take and respond to those warnings being issued. DALART has the early warning system that we communicate this, and we do this on a daily basis as long as the Weather Service has issued the fire warning, and we really communicate to make sure that the farming community responds. And we share this with the province as where our farmers are, and make sure that this thing are effectively communicated and measures to be undertaken to reduce that negative impact. Next slide. The farming communities are encouraged to be part of the Fire Protection Association in order to benefit from the joint resources to better prevent the spread of wildfires. We are quite aware that this is the joining of FPAs from the communal setting has been a challenge, and we have been encouraged on that. But I see when my colleagues from DFFE presented to to really try to make sure the communal settings that we able to be easier with the chief to be able to participate in that. Maybe that will be leasing their participation. We also encourage farming community and landowners to create and maintain fire break as one of the structural mitigation measures of veld fires. And we support farming communities who do not have resources. There are some structures and funding resources that we try to get and budget for and assist, especially on the communal setting, to make sure that we assist these farmers in creating fire breaks where necessary and where the resources are within our plan. Next slide. Overall management of the fires within the department is both national and provinces. We conduct inspections in the farms to identify the risk that will lead to the start and spread of veld fire prior to the season, and this is one of the key performance areas that need to be done. The risk assessment need to be undertaken. This includes looking into the frequency of fires in the areas, the fuel load, existence of breaks, and the ability of the farming community to fight the fires should it start. One of the challenges that the sector is faced with is good to have good rains that it will increase the fodder on the ground, but it also becomes a risk as we come into the winter, becomes the fuel load is high, and this can lead to higher fires to destroying the fodder. This is also used to identify farmers and landowners who need support with the creation of fires to prevent the mitigation in the impact of veld fires. So we fully throughout working with the province to make sure that this task is being taken fully on the ground, liaising with our colleagues at PDMC and NEMC to make sure that where we need assistance, they are part of that. Next slide. In case where the veld fires hasn't been reported, assessment are conducted and reported and are reported to the national. Where it deems to necessary in the national center or in the NDMC has declared a state of disaster following the veld fires, the concerned municipality must do so in line with the disaster management legislation, as well as the provincial colleagues need to do those things. So this is as per the Disaster Management Act, following the plans that we drafted, that we need to make sure that we follow the line, the act as it is, following the declaration and approach all the line functions to declare. In conclusion, Honorable Chair, DLRT will continue partnering with the DFF to address issues of veld fires, yes, as well as COPTA, as we are currently having our act, our plans within the Disaster Management Act as it is, and it's being effectively be implemented. Thank you, Chairperson.
Thank you so much. Thank you, Dr. Kakatsi. It's much appreciated. Is the South African Weather Services ready?
Good afternoon, Chair, honorable members, colleague, Deputy Minister and colleagues. Yes, we are. Chair, I'm just going to briefly introduce the presentation, but it will be done by Dr. Mary Jane Bopape. I think, Chair, a lot of mention has been made about the role of South African Weather Services.
Where are you, CEO?
Chair, can you hear me?
We want to see you as well.
Oh,
It's
sorry, Chair. I thought. Oh, sorry. Sorry, Chair. I have my camera on, but there's a little clip on the top that you have to also open. This one has double protection. My apologies, Chair.
Thank you.
Chair, I'm not going to waste too much time. I know we're the last on the list, so I'm going to ask Dr. Bopape to just proceed, and then we'll deal with any questions if there are any from the honorable members. Thank you, Chair. Dr. Bopape.
Thank you, CEO, and thank you, Chair. Good afternoon, honorable members and the honorable Deputy Minister. I'm just going to put this slide in slide mode. If you can just confirm that you can see that, okay?
Yes, yes. Can see.
All right, thank you. So the presentation that I will be taking you through just describes our role as the South African Weather Service in relation to this National Veld and Forest Fire Act. So the the presentation is structured such that we will discuss very briefly the legislative underpinning of the work we are doing. Then we will speak to the responsibilities of SAWS in as far as they speak to the particular act that we are speaking to right now. And then we will show what we are doing as the South African Weather Service, in responding to our responsibilities on this act. And then finally, I will conclude. So as the South African Weather Service, our work is underpinned by the South African Weather Service Act. It gives us the mandate to provide meteorological services for the benefit of all South Africans, and with because of the act again, we can provide public good as well as commercial services. And the act also states that as the South African Weather Service, we are the only organization that may issue warnings that relate to severe weather. And this is to ensure that there is a single authoritative voice in this regard. We know that hoax messages can lead to a lot of chaos. So it's important that we know who the authoritative voice is. Our work as the South African Weather Service links up with the Disaster Management Act. We know that the majority of the disasters that we experience are hydrometeorological in nature. We get floods, we get storms, we get droughts, and we also get fires as we are discussing. And as SAWS, we issue early warnings, and our warnings assist, towards the, prevention or reduction of, the severity that can be associated with the disasters. So that we do interact with the structures that have been implemented through the Disaster Management Act, so that our early warnings filter through, different spheres of government. So our role is described in Chapter 3 of this Act. So there is Section 9 to Section 11, is Section 11 in Chapter 3 of the Act. Section 9 speaks to the actual calculation of the fire danger rating. Section 10 speaks to the communication of the fire danger rating, while Section 11 speaks to the delegation of powers and duties. I will just speak through at a high level what these sections are talking to, and after that, then we'll look into whether, as the South African Weather Service, we comply with these or not. So the Section 9 describes the variables that are of importance or conditions that need to be considered when we calculate the fire danger rating. First, the danger rating has to be calculated for separate regions, that can have a similar number when it comes to this fire danger rating. The calculation needs to consider the topography, because we know that the slope can have an impact, on the fires. It needs to consider the climatology. It needs to also consider the weather conditions and that are occurring right now, the previous few days, as well as the forecasts. And so as the D there says that, after we have calculated this fire danger rating for a period of time, we need to also identify what activities are dangerous and what precautions need to be taken when the fire danger rating is high. Then Section 10 speaks to the communication. 1A says that the rating needs to be communicated regularly. B says that when the rating is high, the warnings need to be, communicated through at least 3 television stations, television channels, and 3 radio stations. And the warnings need to be communicated through at least two newspapers. And then they also speak, of course, to the archiving of this information. Then, so I'll just jump straight to section 11, which then says that the responsibilities in relation to this chapter can be delegated to the South African Weather Bureau. And as we've already heard, this is one of the amendments that's being introduced, that our name is being changed from South Africa, because right now we are South African Weather Service, and when the act came into effect, we were South African Weather Bureau. So now I'll get into what it is exactly that we are publishing. So the first part speaks to the communication part. So this speaks to section 10 of the act that says we need to publish the warnings in at least 3 television channels and 3 radio stations and 2 newspapers. So we update the fire danger rating on a daily basis. We calculate it on a daily basis, and we make calculations for all the districts. And this communication is communicated on the whole map of South Africa up to 3 days ahead. Our information is shared through email lists. And in terms of our warnings, we do issue information, our weather forecast, the minimum temperature, maximum temperatures, expected rainfall, including the fire danger warnings to a lot of media, to many media houses, traditional media houses. So our warnings do get distributed to at least the 3 that the Act requires, but we do a lot more. So the parts that are indicated in red there are the extra platforms that we use to disseminate the information. The rating is available on the source website. It's also available if you go to some of these the online electronic news sites. You will find our information there. We've got social media pages on Facebook and on Twitter. We share information. We do provide some briefings on YouTube on a regular basis. Our information is shared on SMS. We also use the Common Alert Protocol messaging, and there are also WhatsApp groups where we are communicating for disaster management, where we share information. And we also have a Weather Smart app. So it's a mobile app that is available for free, where we provide our weather information. So the Act says that we need to provide, so we calculate the rating, and then we also need to provide information on, what can be done. And you can see that we've got different colors there that are associated with different categories. And with each of these, there is a precaution that is associated. For example, if when it's blue, we say it's safe, then you can have controlled burning. And then, you go all the way as, the colors change from green, yellow, orange to red. We get to a point where now, we get to a point where it's extremely dangerous and there shouldn't be any fires that get ignited. This is the maps that we are producing that I said we update on a daily basis. The ones that I'm showing here were produced last week on Friday, 4 February. So you can see a map for the whole of South Africa. On that particular Friday, we can see a map for 5 February, as well as a map up to Sunday. So as I indicated, for the whole of South Africa, the map that we show on the website goes up to 3 days ahead. So when you look at this map, you can see a trend. So if you are looking and you want to know what is happening across the whole country, this map provides that information in a better way. Then we also have a product that we produce for different provinces. So the lead time indicated in the previous slide is only 3 days, but actually we calculate the fire danger index up to 7 days ahead. So there is a file that is generated every morning that indicates the fire danger rating up to local municipality level. So you can see, I'm showing you here 2 examples of 2 districts in the Western Cape, and with a fire danger rating for each of their local municipalities. So this information is available for each local municipality, and with a lead time of up to 7 days. We of course update this on a daily basis, as I've already mentioned. So in conclusion, we will just like to say that we are continuing to implement the functions as delegated to us by the Ministry of Forestry, Fisheries and the Environment. And as we are doing this, of course, on behalf of the department. We are collaborating with the Council for Scientific and Industrial Research, the CSIR, to improve on this rating. So the aim there is actually to see if we can increase the temporal as well as the spatial resolution of the fire danger index that we are calculating. And we continue to engage with our mother department, the DFFE, to ensure the successful implementation of the Act and to safeguard against fire hazard. This is my last slide. Thank you. Thank you, Chair.
Thank you so much, Dr. Upape. It's much appreciated. Colleagues, let me see show of hands for the presentation by the NDMC, Department of Agriculture, Land and Rural Development, and the South African Weather Services. Honorable Phelps' hand is up. Who else want to comment? For now, I only seeing the end, and then it will be Honorable Hancho in that order.
Thank you very much, Chair, and thank you for these presentations. I must say that the weight of a burden that we carry as a portfolio committee member making decisions about fire is very, very heavy, and it's very real to me. So I just would like to know, on slide 6 of the Disaster Management Act, the presenter said that the municipalities or the district municipality may make bylaws. What happens if they don't make any bylaws? How do we present the fires and how can we hold them accountable? I know of municipalities that don't have any fire bylaws or firefighting bylaws. Then I would like an answer to this. It might not be available at the moment, but if the department could try and get the answer and send it to us, that would be great. The funding and the resources that are allocated to the different provinces for the Fire Protection Association, what is the, or what was the budget for 2020 and 2021? And then how is it distributed? How's the determination done? Is there a formula, or how's the determination done? Because it seems that there are some provinces who are very well equipped and who are well financed, and then there are the poor cousins that don't seem to get quite as much help. So I'd like just if we could have that information provided to us, that would be amazing. Thank you very, very much.
Thank you so much, Honorable Phillips. Honorable Gansha.
Thank you, Chairperson. I am partly covered by Honorable Phillips. Chair, I wanted to talk on this issue of disaster management centers. I know that they are the functions of district municipalities. And I know that our LMs, they only deal with domestic fires, but unfortunately there are LMs that also get impacted by the Veld fires. But Chair, I just want to make a comment that we need to adequately equip those district municipalities, more especially when we are saying that they must execute these functions. Because we, as I have mentioned earlier, that you have municipalities that do not have even off-road fire trucks, but we expect them to deliver service. And also even in cases of floods, you may see that these district municipalities, they are just there, they are not assisting because of the equipment that they do not have. So we really have to adequately equip them so that they can deliver services to our people. Thank you, Chairperson.
Thank you so much, Honorable Gancho. The issue that I want to be clarified on, Deputy Minister, is with regard to the tagging of this bill. This bill, it's tagged as a Section 75 bill. And I think it seems problematic as it affects provinces and municipalities, even though it's going to be administered nationally. And we know the argument that you're going to bring is that the chief state law advisor is advised as such. But I think all ourselves as legislators must be concerned, because this is meant for local applications. And one is of the view that it should be tagged as a Section 76 bill, and it must be consulted with the National Council of Provinces. And then the other issue with regard to the transfer of this function from water and forestry then to the department. And having listened to the National Disaster Management Center's presentation, you recall the grants that COPTA give with regard to disaster grants. It doesn't also deal with the fire-related incidents. Don't you think that there has to be a memorandum of understanding with the National Disaster Management Center, as that has been the case in the past with the Department of Agriculture? I think this then will assist a great deal if you are to enter into that. And then we then also with regard to the bill, because I shared with you colleagues the interpretive memo of the same Act, Veld and Forest Fire Act 101 of 1998. And then when you go through that 49-page document, it's very eloquent on what needs to happen. Should it be made to my understanding that even on this one, the department is going to have a memorandum of object which explains the text? Because looking at it as it is, I think it's shallow now. But that other one, the previous one, did you take consideration in that, so that you do a similar one like you've done in the act that you tend to amend? So those are my issues that I'm glad that the Weather Services and the Department of Agriculture, including the National Disaster Management Center, they've managed in their comments to show the interrelatedness and how then they will respond once the bill becomes the act, it's enacted. So basically, those are my major issues that I feel they need to be responded to. And in the absence of that, then it means as and when the question get responded to, will be coming to the end of our meeting. Over to you, colleagues. There isn't much, it's only the issue raised by Honorable Phillips, I think, to the National Disaster Management Center, and these other questions that are directed to the Department of Forestry, Fisheries and Environmental Affairs. Who wants to start?
Chairperson?
Yes. DM.
Thank you, Chairperson. I would like to just indicate that on your issues that you just mentioned, we just had a discussion, myself, Pumeza, and Linda, and I would like, especially on the issue of the MOU that you touched on. I'm happy that the Department of Rural Development and Agriculture mentioned the fact that the branch was always with agriculture until 2 years ago when it was then transferred to environmental affairs. Can I then, Chair, request Linda and Pumeza just to in 2 minutes to touch on the issues that you have raised with regard to the MOU with National Disaster Management. Thank you, Linda. Pumeza.
Thank you. Thank you, TM. I don't know if I'm audible now. Honorable Chair, am I audible?
Yes, you are.
Oh, okay, okay.
You are.
Okay, okay. Thank you, DM. I think in terms of the issues that has been raised by the chair, we are working together with the NDMC on the amendments that we are doing, but I think further collaboration obviously would be required in terms of the other matters to make sure that the implementation of the Act is strengthened. And so I would support that there is a need for us to have some that collaboration, and this will also assist us as we implement the Act, but also as we also implement the Forestry Master Plan, which I had indicated earlier that it had identified some issues in relation to fire that needed to be attended to. And one of those issues was the amendment of this bill. So I think from our side, we will have further collaboration with the NDMC, and we will continue to have engagements and discussions with them and come up with some sort of mechanism for collaboration. Additionally, I think the issue raised by the chair in terms of the detail that is requested on the information for the bill is something that we can look at and just make sure that we cover everything, especially with the discussions that we've had this afternoon. Thank you.
Okay.
I think Linda will deal with the issue related to the tagging, Chair.
Yeah, and through your chair, also Linda, please try to respond to the issues that has been raised, especially those issues that are legal in its nature, like Section 75, Section 76 of the bill, as per the chairperson's consent. Thank you, Chair.
Thank you, Chair, and thank you, honourable members. The tagging is usually not dealt with by the department. In the preliminary legal opinion that the state law advisors provided to us, they have explained that normally how they do the tagging is they see whether the matters dealt with in the bill are predominantly falling within Schedule 4 and 5 of the schedules to the Constitution. So, and for that reason, they have tagged it as Section 75 bill, because they found that it doesn't fall within those schedules predominantly. And I have checked prior to this committee meeting whether this bill was in fact tagged. And it was also tagged, I was informed that it was also tagged by the Tagging Committee of Parliament as a Section 75 bill. If there is uncertainty, maybe it could be dealt with by the Parliamentary law advisor in that respect. I have also been asked whether the 2005 Memorandum of Object to the National Forest Veld and Fire Act had been updated by the department. How it usually works is that each bill got its own memorandum of objects that explain the text in the bill. And the question is then whether we couldn't just align it to refer also to the other, to maybe explain the interaction with the other legislation. Since this bill is meant to do alignment, maybe that can be better explained in the memorandum of objects, maybe also in the purpose of the bill, or even in the preamble. It's something that we can look into. DM, is there anything else I need to respond to?
I think that was all on the legal side. I don't see anything that I have noticed that you haven't responded to. Thank you.
Note the head of the National Disaster Management Center, Dr. Town. Then I think Honorable Singh will come after Dr. Town. Dr. Town?
Thank you very much, Honorable Chair and Honorable Members. We appreciate the guidance that has been provided. I thought I could just touch on the few points that have been raised, which have a bearing on Disaster Management Center. The first one, Chair, is the matter that was raised by Honorable Phillips in respect of municipal bylaws. And my response will take a form of, shoehorning the response from the perspective of the Disaster Management Act and the Fire Brigade Services Act. And as a point of departure, with regard to Disaster Management Act, my colleague has already indicated that our focus is to ensure that we emphasize on prevention, preparedness, and mitigation, and that municipalities must develop and adopt disaster management plans based on their risk profiles and implement those plans, provinces and national sector departments and other entities. So from a disaster management point of view, once the plans are in place at municipal level, that then and are implemented, that gives us a reasonable level of assurance that risks will then be managed. But I think the key point Honorable Member was raising relates to adopting bylaws relating to fire matters, whether it's structural fire or it's wildland fire or vegetation fire issues. But we have done, in 2014, we adopted what we call the fire safety and prevention strategy. And in terms of that, we currently in our APP that our minister tabled and was adopted by Parliament, identify municipalities that we assess their capacity to implement the Fire Brigade Services Act in line with the fire safety and prevention strategy. And the issue of bylaws is one of the focal areas that we assess. And I want to indeed concede that some municipalities are not at that level of having the bylaws, but as part of our support to them, we ensure that we give them feedback and bring on board, other support measures such as, training. We have a MOU with Fire Protection SA, and also where possible through funding from the private sector, we do provide equipments. We have a partnership with Santam and others that is enabling us to achieve that. So it's an area of improvement that we have also taken note of. So I wanted to just underscore that important point. And Honorable Khanso, you correctly stated the fact that the issue of disaster management, particularly fire service in some areas, is a district function, but in some areas is also a local municipality function. For instance, Polokwane and other municipalities. But if you look at it from disaster management point of view, and this is something that we always strive to clarify, all municipalities are required to assess risk in their areas of responsibility, whether it's risk in terms of hydrometeorological hazards, geological or geophysical hazard, or epidemiological or biological hazards and anthropogenic hazards that might also occur in their areas. So even local municipalities are required to adopt disaster management plans and implement those plans in their areas of responsibility, because disaster management is integral to delivering on their municipal integrated development plans. So they must make sure that there is risk-proof their IDPs. So they have that responsibility, and we always encourage them. There are also best case studies of municipalities, local municipalities that have robust and are implementing disaster management plans, such as Polokwane, Tlokwe, by the way, it has changed to JB Max and others. So, of course, with regard to fire services, other local municipalities will not be having the authority as conferred by the MEC, but their partnership with the district will ensure that there's capacity built in those areas. The last area is the important points that were also raised by the chair regarding collaboration with the National Disaster Management Center. I think from our two mandate areas, which is the Disaster Management Act, we would indeed like to have that collaboration, stronger collaboration, so that, you know, within the value chain of managing disaster risks, we can be able to see how issues of fires are actually addressed, because there's still some bit of gray areas in terms of how do you ensure escalation in the event of dealing with fire incidents, and how do we ensure that there's also support from our disaster grants, which until now have mainly been dealing with issues of infrastructure, issues of drought relief, sinkholes, and so on and so forth. So we'd like to bring on board the issue of support to fire damages, but not overlooking the fact that sectors still have a responsibility to budget for and fund disaster risk management processes. The last issue is on the interpretative memo on the National Veld and Forest Fire Act, as highlighted by the chair. We are so much encouraged about that, and I think because of the interface or conceptual interface and the application alignment that is required between the Fire Brigade Services Act, which we now are working on the bill towards a Fire Services Act, and the National Veld and National Forest Fire Act, it is important that we work together on the interpretative memo on the act, so that interpretation and application can be seamless across the whole country. So thank you very much. I thought those are points that I can deposit through you, Chair. I'm not sure whether any of my colleagues would like to also deposit something. Thank you.
Okay. Then I was going to allow Honorable Singh to ask his question, but he has put it there on the platform. And he's saying there is some construction going on at my place here, hence the noise. Then his question is whether we have a legal person from Parliamentary Services to support our committee. Perhaps we need to want to work with DFFE and the state legal advisors to finalize the tagging. I should take this as a, your hand is still up. You still want to say that, Honorable Singh? Has the noise subsided? But I got that question.
Yes.
Okay.
Yeah, sort of. It's intermittent noise. Yeah, but thank you, Chair, for reading that question. Normally, you know, we have advisors. I mean, you know that in our committee, and perhaps they need to work with the others to check on the tagging.
Does the matter that I felt I need to follow up, like, because if indeed they've wrongly checked it, it's a problem. Because this is it's supposed to be a section 76 that will deal with that. I think the team has noted it. We were going to write to the legal services, and then there was an apology earlier of the person whom I'm told supports the committee. There was somebody who did the presentation on his behalf. Then we'll take it further. That's the matter that we are going to take it further. Then hence I wanted the department's opinion on the matter, because matters that affect provinces, they should be taken as a section 76. I don't know why 75 this one, but these are the matters that we are going to take further. Having said that, colleagues, I think you wanted to add more, or that was the only issue, Honorable Singh?
No, I'm fine, thank you.
Having said that, colleagues, the committee secretariat had already propose a plan for the advertisement. Now that we've considered all this, then we need to advertise this bill for further comments. Normally, the requirement, I think, is 2 to 3 weeks. There's a timeline. It's going to be shared with you to say when are we going to. I'd since asked them long ago to look for quotations. And at some point, the plan that we make, Honorable Singh, will target all these mainstream media, forgetting the actual affected people. That's why I'll prefer us to target the community media in particular, so that in the parliamentary website now, everybody now is on Zoom and everything there. Much of the people are online, so that we make sure that we advertise it. And then get the comment of various stakeholders, everybody who's affected, that will assist at a grading. Post that, after receiving the comments, then we'll be able to reschedule it. Definitely that should be in the next quarter. But I should sincerely, Honorable Singh, your hand is up.
Yes, very quickly while I got him. I don't know, Honorable Chairperson, this has been a very useful exercise. And following this exercise and the questions, whether the department, DFFE, and the other departments want to have their own tete-a-tete to see whether there's anything that they need to re-look at before we kind of advertise it. Is that possible from a legal point of view? Because this hasn't been tabled as yet. I don't know, the Deputy Minister can probably answer, or the legal advisor.
DM or Linda, you want to respond to what Honorable Singh has raised? I see Linda.
Chairperson, I with regard to what has been raised by Honorable Singh, earlier I've spoken to Linda when you indicated about the piece of legislation that they referred to, which then Nkosikazi indicated that that piece of legislation has been repealed. Therefore, we said among ourselves, we have to go back and recheck. So I think it will give them time then to attend to the issues that has been raised by Honorable Singh. But I'll hear what Linda is saying. But it's what I think we should do in going forward before it get advertised, because of those blunders that are there in the amendments. Linda.
Okay, thank you, Dean, and thank you, Honourable Chair and Honourable Members. I've just got a message from the law advice or my legal team that assists me on this, and I said the references of those acts even appear up to today on LexisNexis and Subnet, and it may be that the other act is not in operation yet, that it is an act but not in operation yet. So that might be the reason why we haven't picked it up. But we will definitely
which act, Linda? Which acts?
The acts that have the incorrect cross-references.
Because the TKLA Act is functional, you know.
It's functional.
Started to operate 1 April last year.
April. Okay, we will definitely recheck that, Chair. But it's just that they told me it's still on LexisNexis, so we definitely need the opportunity to recheck that. And then I would welcome that we maybe sit and quickly look at the bill and in light of the comments raised today, and that we maybe address the committee on that before it is published for public comment. We can work together with the state law advisor, and we usually work with the parliamentary advisors as well, Chair.
Then we are going to, on our part, we've already got the codes. Now we need to choose which papers we're going to advertise on, and then we'll submit to the House Chair for approval. As I've indicated, we usually give stakeholders a month to submit comments. Then definitely the next term will be preoccupied on processing these bills. So whatever needs to be refined, it has to happen now. Then in between, while we're busy seeking the approval for the House, from the House Chairperson to approve the advertisement, then we'll be able to infuse whatever is due. Then the proposed closing date for written submission will be the 18th of March. It's then post that. That's why I'm saying we'll be able to schedule this in the next term. But having said that, colleagues, I should thank you, especially on a Friday, to be in meetings up to this time of the day. Honorable Phillips sent something that she's also tired and burning out in the group, then she deleted. But the beauty about it, then I do sympathize with the colleagues, but at the same time, I think we need to push this. And I'm so inspired by your commitment and dedication. So I plead with you that you take time to rest the weekend. It's very exhausting, I agree, but we are dealing with people's lives. So that's how that keeps us going, definitely. Then to thank the entire teams, starting from you, Deputy Minister, the department, colleagues from the National Disaster Management Center led by Dr. Dow, SALGA, the Department of Agriculture, and then the South African Weather Services for taking, including the National House of Traditional Leaders, for taking time and spending this time with us here. And I know this is a matter that is so close to your hearts, all of you. As Honorable Phillips says, that this affects a lot of people, and we all agree that fire is so frightening. Once it happens, you know what happens when everything gets lost. Animals, properties, assets, lives. It's a matter that you cannot take for granted. And so we need to also appreciate UDM for initiating the amendment of this bill so that we are also in line with the climate change requirements, as Nkosikazi Ngonyama referred to it as she was presenting. So let's end it here. You must have a great and fulfilling weekend till we meet again on Tuesday next week. Thank
you, Chair.
Thank
Have a good weekend, everybody. Bye.
Thank you, Chair. Thank you, everybody.
Thank you, everyone. Have a good rest. Bye.
Bye.
You must rest, Honorable Phillips. You must rest. You're dealing with waste next week.
Chair. Thank you.
Dealing with waste, another contentious issue. Thank you.